meeting to order at 4. This is the meeting of the Sunshine Ordinance for February 7th, 2018. On the call, the roll. Member Eldon. Eldon excused or absent? He did inform us that he was unable to attend due to work circumstances.
Okay. Excused.
Excused. Member Josh Wolf.
Present.
Wolf present. Copra absent. Member Tesfa. Tesfa present. Member Moss.
Present.
Moss present. Member Kanata.
Here.
Kanata present. Member Fisher. Fisher absent, but she is currently on the way. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland.
Excused.
Excused. Chair Wolf.
Here.
Wolf present. We have a quorum.
Thank you. All first item. Wait, let's just ask, any agenda changes, adjustments? Yes.
Yeah, so I'm just looking at the agenda. This is really... Oh, never mind. Sorry. I was concerned that we would not have a quorum for item 3, and so I was going to request to move it, but we have quorum for 3 now.
Great. Okay.
Yeah, but Josh may have to recuse himself from it, so we would be down to 5.
Okay, let's move on. Seeing no agenda changes, called. Next item.
Next on the agenda, item number 2, approval of minutes for the Sunshine Ordinance Task Force January 16, 2018 meeting.
Any changes, adjustments, edits? Is there a motion?
Move to approve. Second.
Moved by Member Kanata, second by Member Hinsey. Any public comment on the minutes? Pertinent to the minutes. Go ahead.
Hi, Michael Petrellis. I'd like to make public comment on item 2, the minutes from your January meeting. The first thing I want to say is, in looking over these minutes, I don't see anything about the absence of an assistant district attorney at the December meeting. I believe it was at the December meeting where you had to continue my complaint that you'll hear later on. It had to be continued because we didn't have an assistant city attorney here to weigh in on matters related to whether a member could stay in the room when we have that debate. I think it is very important that we find out why the city attorney was derelict in his duty in not having an assistant here to advise the Sunshine Ordinance Task Force. The second item I'd like to address is my complaint was item 6 on your agenda, and thank you for continuing it. I was staying at home because I thought it was a flu thing I was dealing with, so there was no way I was going to come here or go anywhere really because of the ailment. So that's it. Thank you.
Thank you. Any other public comment on the minutes? Is there anything else for the minutes? Okay. Call the roll.
On that motion, Member Kanata.
Aye.
Kanata, aye. Member Hinsey.
Aye.
Hinsey, aye. Eldon, absent. Eldon, excused. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Fisher.
Aye.
Fisher, aye. Highland, excused. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Item.
Next on the agenda, item number 3, file number 17094. Complaint filed by Michael Petrellis against President London Breed, Board of Supervisors, for allegedly violating Administrative Code Section 67.25 by failing to respond to immediate disclosure requests in a timely and/or complete manner.
Okay. Do we have Juris Complaint Committee?
We have already determined that we have jurisdiction.
Okay.
I believe the issue was Member Josh Wolf.
So at the previous meeting, there was a motion to recuse myself, which brought open the question whether or not, or I'm sorry, not to recuse myself, to recuse me,
which brought to question whether or not it was feasible for a recused member to speak during the public comment or on behalf of a petitioner about additional facts and evidence. That question was uncertain.
At our last meeting, we did resolve that question. We determined that if you do recuse yourself, you are required to leave the room. However, you are allowed to come back as the last speaker of public comment. I will come and get you, and you can speak during public comment.
During public comment or facts and evidence? Because
Public comment.
what I actually have to say pertains to facts and evidence related, so shouldn't it be during that point of the meeting?
We didn't discuss that point.
The way the ordinance talks about public officials is with regards to public comment. It does not speak to whether being a party of a case or not.
So then the issue of speaking during facts and evidence is resolved through the lack of speaking to it, is what you're saying?
It would be more or less, since the law does not allow it, it would seem that your only option would be for public comment.
But the law also doesn't disallow me from speaking during the facts and evidence part. So.
But if you're recused, it causes you to be removed from the proceedings of the meeting.
I hear what you're saying.
Public comment being only for the motion that is on the floor.
No, I understand
Okay.
exactly what you're saying.
Okay.
I disagree with the interpretation, but I'm not going to further the point.
Okay. DCA Colo, do you have anything to add?
When this issue was brought to my attention, it was my understanding that I was interpreting it from the perspective of someone's recusing themselves, but they still want to take part in public comment, not speak on behalf of not speak on behalf of a party providing facts and evidence. So I'd have to look into this a little bit more. It's my understanding, and I was fine with allowing public comment, but having that particular member that recuse themselves as sitting outside and then being the final public commenter, so not as to influence other members of the public or to influence the body in their decision making process. So I don't really know. There's nothing that I researched that indicates that they can't be a party or they can't speak in support of a party. But it also doesn't. It doesn't seem like that would be proper to me. But I don't have anything to back that up at this moment.
Through the chair?
Yes.
So, DCA Cole, when you say you're not sure it's proper at the end of that sentence, what did not seem proper?
Basically, a member of this body would be recusing his or herself so they could be a party to a complaint that this body is going to oversee. It just, I don't know. It just doesn't seem like that's right to me. But I don't have anything to confirm that right now. They wanted to speak in public comment, and they said, and the body's okay with recusing them. I see no violation there, and I don't see any ethical issue with that. But inserting yourself in presenting facts in support of evidence on one side of this when you're a part of this governing body, it seems a little different.
So I think it's important to point out the context that the reason for the recusal is the parallelness between this complaint and the complaint previously lodged by myself on the same subject matter. So in terms of tying the two together, I think they're intrinsically tied together.
So
we take things on a case-by-case basis, though.
Well, I understand that, but the sole reason for the recusal is
because
those circumstances.
Okay. Got it.
I mean, what do you want? So you want to recuse yourself, wait outside, and let him make his case, and then we allow you back in so you can say your piece during facts and evidence rather than waiting until public comment on the matter?
That's exactly my suggestion.
All right.
So let me put that before the body. It's just because the recusal is our decision, and how people, I want to get an idea how people feel about that. Because it was also my understanding that it was just going to be for public comment. It wasn't going to be for...
Sorry, I thought I had made that clear at the time, but perhaps it got lost in the wash.
Yeah. Okay. Member Moss?
I mean, to me, I feel like Member Wolf testifying during facts and evidence is the appropriate place for him to do it if it is facts and evidence that he is giving. And I don't think if you are a witness, you're a witness, but I would not want to delay this complaint further in order to explore this and have to wait months more until we address this. And I think that if we can, if Member Wolf would be okay with recusing himself and going to public comment, and that way we can just move forward with this, that would be fine. If we can make a motion, and that's within our power to make a motion to allow him to do it during facts and evidence, I would make that motion, but I would just hope that we could deal with this today.
Anybody else? Member Luong?
Member testify. I would not feel comfortable having Member Wolf speak on the facts and evidence of this case, given the clear similarities to a complaint that he has also lodged. In my experience on the state level, when a commissioner is recusing themselves, they leave the room. They do not even return to the room for public comment on the item. And so if Member Wolf will be speaking on facts and evidence, I will abstain from participating in that. I think there are serious ethical issues involved in his influence that he has upon us, as well as influence that I understand that the opportunity for him not to be in the room during public comment would deal with some of those issues. I would have concerns about people in the audience speaking on public comment, potentially speaking out against a position that would hurt his case, and their concern that could affect any case they have before us in the future. And it's not that I think Member Wolf would be vindictive towards someone or anything like that, but it is the appearance and the potential concern that members of the public or other individuals who might have cases before him in the future, and us, given the respect that we have for him, would cause. So potentially him coming in at the end of public comment to speak on the item, I would be okay with that. But if he's in the room during public comment or speaking in facts and evidence, I won't participate on this item.
Member Canada.
So, and this is a question maybe in response to this last item, but how would this differ when Member Wolf's case comes up? People will know he's a member of the task force. Now he's recusing himself during his case because he can't vote on his own case, and the instance of people speaking in opposition to him on his own case carries the same level or some level of them thinking he might be prejudiced against them if they bring cases. So how does that work if a member of the task force brings a case?
Okay, hold on. Member Fisher and then Member Tesfaye.
Yeah, I had this whole speech prepared, and then Member Tesfaye said something so eloquent that totally persuaded me and changed my mind. So, law school worked out well for you, didn't it? So I'm going to agree with you on this. I mean, the thing I thought of at first was, we don't exactly hang up our members of the public when we get appointed to this board. We're still a member of the public, and we're still entitled to all, the rights, et cetera, that come along with it. However, having said that, we also take on, I don't know whether to call it the burden or the privilege of serving on this August board, and with that sometimes you have to compromise. So I'm going to vote, if we're doing that, or I'm going to agree with Member Tesfaye on her, what I call sort of the compromise. I'm fine to hear you during public comment, but
Gotcha.
I don't think it should be facts and evidence.
Okay, Member Tesfaye, then Member Moss, then Member Wolf.
Just to address what Member Kanata was saying, during Member Wolf's own complaint, he has a due process right to be here and speak on his issue before us, and so I don't. So there is a distinct difference between the rights afforded to him when his own complaint is before us.
Member Moss.
Yeah, so I am satisfied with if Member Wolf is still allowed to do public comment, then I am happy to defer to Member Tesfaye's thinking on this. Where I draw the line is not telling him that he can't do public comment, because that would be a violation of 6717 in my view, and so I don't want to go there. So I will not be making a motion to allow for him to speak during facts and evidence.
Member Wolf.
So I understand the reasoning behind the discourse that I've just heard. However, when we really take this apart, I don't even think it's actually all too proper for me to have an opinion on a potential motion on this case due to the potential conflict of interest, and I would not be inclined to engage in submitting a public comment on the motion. What I have to say pertains to objective facts and evidence of the past case before us, and that is why I'm suggesting that is the proper venue for it to be interjected into the conversation.
Okay. So
I mean, a motion's required here?
motion's required to recuse.
So I move to recuse Member Wolf from this item.
Completely? Or to,
I mean,
to allow...
I feel like I don't need to make a motion if the advice of the city attorney is for Member Wolf to come during public comment, and it is up to the chair whether he can come up to the podium or not. So I don't feel like a motion beyond that is necessary.
All right, so there's a motion on the floor. Let's get a second. Is there a second?
I'll second that.
Okay, now, Member Wolf.
I have a point of order, which is I think that the city attorney's guidance was essentially that he didn't know about how the law should break down on this issue, not what you just said.
He agreed that it was okay for you to speak during public comment, and that is where we seem to have landed. I mean, I don't know that there's anything to physically stop you from walking up during facts and evidence, but it is up to the chair to make a decision on what happens at that point. So I mean, I don't know what to say. I don't want to make a motion on that.
No, I just wanted to clarify what I had heard from the city attorney.
Okay. Public comment on the motion. No, it's appropriate because we haven't started the case yet, actually. We're going through a procedural matter. Go for it.
Hi, Michael Petrellis again. A couple of quick items. I'm really glad that you're delving into this. Second item, I'm really disappointed that this meeting is not being broadcast on TV, because I think people, taxpayers, and people who approve democracy should be privy to this very important conversation. The next item is I would really like to hear some facts about the Josh complaint. And my last matter I want to say is that not knowing about this his case, but very much aware of I believe 2 previous complaints I brought against Supervisor Breed, really feel that part of what is driving my interest here is that this elected official has real troubles with transparency. Thank you.
Any other public comment?
Yes. Good evening. Some of you know me, some of you don't. My name is Ace. Ooh. And I've been on this case. No, I'm not going to go through that. Listen, I've been here years ago on the Sunshine, and I appreciate this commission, along with the Ethics Commission. See, because I'm about what y'all supposed to be about, or I guess you are, about the ethics, about government policies being run. And the only reason I came by, I seen the agenda here at London Breed, And this is Black History. I'm not up here to defend nobody, but
I'm sorry. I am going to interrupt you because this is about a particular motion to recuse a member.
Oh, this is not the first one?
We're not there yet.
Oh, I'm sorry.
Okay, I just want to make sure you're speaking on the right part.
A moment, I'm kind of old.
It's all good. It's all good. Usually I wouldn't interrupt, but we want to keep it pertinent. It's all good. No problem. Okay, any other public comment on the motion for recusal? Seeing none, please call the roll.
On the motion, Member Moss.
Aye.
Moss, aye. Member Fisher.
Aye.
Fisher, aye. Eldon absent. I assume that Josh Wolf would be recused from the vote or excused from the vote?
How does that work? I would think so. I don't know whether...
I think we would have to vote to recuse him from this vote, so...
No.
I'll just vote yes to make it easy. Let's move on.
Corporate absent. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Hinsey.
Aye.
Hinsey, aye. Highland excused. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
So you have to... You can't hang out.
Why can't I hang out back there?
Because we all know that you're back there.
Listening, judging.
Wait, but stop.
Sitting
Now
in judgment.
Wait, we've done in the back room on previous recusals.
we've done people in the back. I should have a right to hear what's happening, though.
Okay.
And
I don't believe it's an issue with the back room as long as
I
he's
sat in the back room.
not visible
Yeah,
to
visibility.
the audience.
we had this discussion about that, and I believe we came up with people were felt uncomfortable with somebody sitting behind them in the back room where they had earshot and they had the ability to possibly communicate. And if
I have a right to hear what's happening in the meeting, right? Like, if this meeting were broadcast, I could go in another room and watch it, but the meeting's not broadcast. I don't not really understand. Like, it's a public meeting. If people are concerned about what they say because I could hear it, which I don't completely understand, the tape still exists, so how does that... Is the concern that I'm going to be, like, texting someone?
in general case, in all the commissions and bodies in the city, when you're recused, you leave the actual room.
But they walk to the back.
Sometimes they do, but they usually lots of times they walk back there to leave. They don't walk out through the front door. They walk out through the back door.
Can we not put him in this room over here and close that door? And he can
You could do that with both, but they're both connected. So
Can we just close the doors to make this...
If everybody's comfortable with that,
Yeah,
I'm okay with that. But
I don't care if he hears it. He could listen to the tape anyways.
Yeah,
right, but that's not during the proceedings. So that's the difference.
If the
Splitting
meeting were
hairs
broadcast
here.
live, one could listen.
Then you could be in a different part of the building and watch it.
How is that any different than being in the other room, though?
Because
just
we
have a
know you're back there.
Vote, a hand vote.
I don't understand how that fundamentally changes
perception.
anything.
Everybody just
Okay,
raise their-
never mind. If
We're
you
good.
want,
Go.
I'm okay. If everybody's okay with it,
We're all
fine.
totally okay with this.
right. Okay.
If you go, bye-bye.
It's fine. And we'll close those doors.
Oh, I could leave the doors open. Now the microphone is behind.
This matter was heard by the Complaint Committee on September the 26th. At that meeting, I do not believe that President Breed or her representatives were present at that meeting. Mr. Petrellis did state that he has not received a response of any kind from the office of President Breed.
Okay. Okay, let's begin. 5 minutes.
Hi, Michael Petrellis again. So, in August of 2017, I filed a public records request with Supervisor Breed's office for a list of the people she blocks on Twitter. And at the time, her Twitter account, which I have up on the screen, and hopefully you can see it on your personal computers, on the left there, it did not say paid for by anyone. This sentence here about paid for by London Breed for Mayor 2018, financial disclosures are available at sfethics.org. That's new. I believe in my original complaint submitted to Victor, I included a screen grab of what her Twitter account looked like at the time. The point I'm trying to make is that this is a Twitter, this is a social media account that she uses for government business. That said, since August 28th of 2017, I've not received any correspondence from her office, no acknowledgement that she received my request, and certainly I have not received the list of who she blocks on Twitter. In the packet today on page P15, under legal analysis from the city attorney, they under the section questions that might assist in determining facts, they first say, did complainant ever receive a response from Supervisor Breed? I've already answered that. No, I have not. How does complainant contend that the records requested should be considered public business? I believe I've established that this social media account is where she does conduct official City Hall business. And the last question the city attorney asks is, how does Supervisor Breed contend that the records requested should not be considered public business? My understanding is that she herself nor anyone from her staff has deigned to come to this task force and explain themselves. And if I'm wrong about that, please correct me. I would really like for the task force to consider finding her in violation because she's not provided me with the responsive records. Thank you.
Any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent? So respondent present. The respondent is not present. Are there any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members?
Through the chair.
Oh,
No, go
please.
ahead. I'm still forming.
I feel like there are a lot of issues here.
Yeah.
One is the lack of a response to an immediate disclosure request. Another is the lack of sending somebody here to explain a withholding of records. And then finally, I would add that I am concerned that there had been a whole hearing about a fairly identical case in which we had found a violation, and yet the problem has persisted with the same ruling. So this is actually a second time that this has happened. And so those are kind of the three things as I see them. I'm not sure if other people see other potential violations or concerns.
Member Fisher?
Yeah, I don't have my book with me today or my code in front of me, but Victor, you can probably tell me, what's the violation for not showing up again?
I don't have the specific code section, but it's failure to send a representative.
Yeah, the failure, it just came up, the failure to send a representative. I would at least start with that and start working our way down from there. That's all I have to say.
Through the chair,
Yes.
I'm also
Member Canado.
concerned about just the total lack of any type of response.
Yeah.
To the complainant, to the committee meeting, to the meeting where we had to continue this, and tonight. This is a request from somebody in the public for information that should not be hard to provide.
Yeah.
And there's nothing. So
He hasn't received
I don't know if we're under the new rules yet with ethics about how we send stuff to ethics, but
We are. Those rules have been approved by the Ethics Commission.
so I
Well,
could hear a discussion about that possibility.
Well, let's talk. Okay, so I'm hearing procedural issues. Are there any issues with regarding the context of the actual complaint itself.
Well, I feel like through the chair,
Yes.
I feel like I can't even, I'm sorry, Mr. Petralis, but I don't feel like we can even delve into the complaint because maybe there's a really good reason, and maybe somebody from President Breed's office can come in and tell us that, but I don't feel like I can even delve into this or rule on it fairly or unfairly, whether it was the information was given or not, other than failure to send a representative, and they've probably gone beyond the 10 days. That's all I got so far.
Okay, so I just for your edification, it's 6721E.
Yeah, thanks.
The last
21.
sentence, it actually applies to the sentence before it, where requested by the petition, the Sunshine Task Force may conduct a public hearing concerning a records request denial. An authorized representative of the custodian of the public records requested shall attend, not may attend, shall attend any hearing and explain the basis for its decision to withhold the records request.
Yeah, I mean, we've this is certainly not our first time having this happen to us, so we've done this many times.
Okay. Anything else? Shall we move to rebuttals? Okay. The respondent is still not present. Mr. Petralis, you have 3 minutes for rebuttal.
Before he rebuts,
Yes.
can I have a point of order here?
Sure.
Through you to Victor, did you get any kind of response at all from
I
the-
have not.
Okay.
Proceed.
Again, thank you for adjudicating this to the degree that you can adjudicate this complaint without the supervisor sending anyone and without the supervisor even acknowledging the task force has put this matter on the agenda. I find that in keeping with her response, I believe it was 2 years ago when I had requested her calendar and did not get it, and eventually 2 representatives from her office did show up. This is after they had blown off a committee meeting, and her aide at the time, Connor Johnston, vehemently was against you finding her in violation for failure to send someone to a committee hearing. And they had the same problem with supervisor's office that led to that complaint, which was documents were not provided. So I am asking you to find her in violation of whatever codes you can find her in violation of, and hopefully we can move this matter to the next level of saying, hey, elected officials have to respond to the Sunshine Ordinance Task Force. Whether they like the person who's filed the complaint or not doesn't matter. What matters is the Sunshine Ordinance Task Force cannot be ignored.
Great statement.
Thank you. Okay, members, is there a motion?
I'll make a motion.
Go ahead.
So my motion, if somebody feels that I'm going too far, I would urge them to move to amend my motion, and I would be open to that. I am going to move to find a violation of 67.21E. This is the issue related to not sending a representative to a hearing of the Sunshine Task Force related to a public record. I would move that we find a violation of 67.25, the entire section related to immediacy of disclosure. And I would further move that this be referred to the Ethics Commission.
You lost me there.
Feel free to make a motion. I would say I would like to see this referred to the Ethics Commission. I don't want to make a finding of 6734 for willful failure because that's not our job, but I would like to direct it to them with the note that this issue has come before us twice now and has not been addressed. And that is my motion.
I'll second it.
Okay, moved by Member Moss, second by Member Kanata. Members comment?
Yeah,
Member Fisher?
I was with you until you did the forwarding of the ethics. Can you dial that back down, and then you'll get your 6 votes, and it'll pass? Otherwise, I won't vote on that.
I would like to hear an argument for...
Oh, I can't even hear.
Well, just move.
Oh my God.
Can we have order? Can we have order in the room, please? Thank you.
I would like to hear something convincing that not to do that, because we've had We went through this process once on almost the exact same request, and we found a violation, and nothing had happened. No further correspondence, the public records weren't provided, none of that. Now we're here again on a totally separate individual. So now a second individual, a member of the public, is asking for these records, and they again have not. This is not like somebody has like the office has responded and say we're going to withhold it, and then we had a hearing. We can't even have a proper hearing on this because they haven't sent a representative and they haven't issued any kind of response to the public records request. So I don't know what to do at this point. If we just sit on it again and then a third one comes to us, what is our reasoning for sending a third one to the Ethics Commission when we didn't send the last two? So that's where I am. If somebody has a counter argument, I'm open to hearing it, but I can't make it at this point for myself.
I'm still not going to vote for that part of the motion, so it's going to go down 5-1. So if you want
somebody
you
else
want to hear
wants
from
to amend it,
everybody
I'm not
else,
gonna-
that's fine.
Member Canada.
I agree with Member Moss in that if we don't send this to ethics, it lets any respondent just ignore the issue. And so they get an order of determination that they violated 6721E and 6725. What's that to them? The complainant gets no documents, doesn't even get a response. So that's why I think this should go to ethics.
Chair Wolf, procedurally, can I make the motion on the first two, and then we vote on that, and then we have a motion on the third one, and then could we do that? Is that
sure?
Like I obviously I don't want it necessarily to fail, but I also don't want this committee to walk out of here not having voted on whether to send this for further enforcement.
Okay. So we'll take your motion, find violation of 6721E and 6725.
That is correct.
Okay, 67.25. We'll do that first.
Should I remake the motion, or should I amend the motion?
No, we are just dividing the question.
Okay.
Yeah. Okay. So that is the motion on the floor. Any other discussion? Public comment on the motion?
Public comment. Yes, I got public comment. It's on the motion. I'm sorry.
Wait, when can John?
On this specific motion to find a violation.
Right.
Fine, doing a good job.
Should I go get him?
You got my approval, stamp of approval. So they've got the people out here, the peanut gallery, trying to tell somebody how to shut up. This is City Hall, girl. Black History Month, too.
He doesn't want to come.
He doesn't want to come.
Where I am.
Okay. Is there any public comment specifically on this motion to find a violation of 6721E and 6725? Public comment on this particular motion.
On this particular moment, because
yes.
y'all doing a hell of a job. I just happened to walk through City Hall and just happened to stop here in Sunshine, y'all. My name is Ace. I'm on the case. Let me just say one thing. Y'all are doing an extravagant job. Look here. Your commission and the Ethics Commission is like sunshine to a person that haven't seen in years. Because what this gentleman has just brought to you, I brought to y'all, most of y'all wasn't here, same thing. And it just happened to be, let me just say this, Black History Month. I ain't saying this because I disagree with London Bree, because she's straight from the projects, so am I. But I'm on the outside. And this is it's not a racial, it's not a gender issue, it's politics. Because City Hall is full of it. I call it Silly Hall. But now y'all could change it to City Hall, but it's silly. The politics is crazy. I'm 63, and I may look younger to y'all, but I've been doing this a long time. Y'all could attest to that. This young man over here, he must be a lawyer. That was very eloquently put. I don't know why anybody on your board would object to that. When they were coming down here, and let me just say this. So if go on record, London, anybody else could say it. It wasn't nothing wrong for them coming down here asking that. London's not above the law. Willie Brown's not above the law. And by the way, Ed Lee, may he rest in peace, because I'm still here talking about the Fillmore Street. Anyway, this is Black History Month, and I don't want to get it misconstrued that I'm here siding with the racists. They're going to call it racist. When y'all call London here first thing, they're going to say, oh, it's racist. No, it's politics. And they've been playing politics for a number of years. And our black population must know the facts. That although we way down here looking like that, we don't have no voting block, so we must coexist with other groups. But what I'm here to say right now, in the budget, It doesn't reflect that. Everything is against us. How can you call it? Equality. All of those things are minus towards us. So let me get back on track, because I was here to speak and I got disrupted from somebody from the peanut gallery trying to tell me to be quiet. I've been in City Hall here for 20-some years, and I done shed some tears as being a black man. But I'm here to say politics is full of tricks. It's time out. And we're going to be looking at this department as well as the ethics, because you got, what's his name on there, the supervisor, he's retired, the judge. And they put a little in the City Hall. I'm able to walk down City Hall now saying politics is no longer going to be going on like it is. I'm really appreciating not only this gentleman here, but this department here, because I'm watching. And it's Black History Month. I will be back to tell you about that later. My name is Ace. I'm on the case.
Thank you. Any other public comment on this motion? Seeing none, please call the roll.
On that motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Oh, aye.
Hinsey, aye. Highland, excuse. Member Elding, excuse. Member Josh Wolf, recuse. Member Copra, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. Is there another motion?
We are splitting the motion, or do I need to make it?
The next motion was to refer the matter to the Ethics Commission.
Okay. So it's split. Okay. So the matter. So the motion on the floor is to refer the matter to the Ethics Commission for enforcement.
So I was saying enforcement, but I do not. Reading the ordinance, it is not for us to handle willful violations.
Right.
But I would like to, in the way that we phrase it or pass it on, that the Ethics Commission is aware that this is not a first-time issue, this is a repeat issue, and that it may warrant them looking at the issue of willful violation. I'm not without making a recommendation to find that.
You don't even have to go that far.
Okay.
You can, if we find that there's a violation of the ordinance, we can just send that to the Ethics Commission for enforcement, and then they will determine whether, how many they get, whether it would be, if you want to add some additional language for them to do that, that's up to you. We can do that.
It would be my inclination to add that additional language, but I'm not necessarily clear about, based on our agreement with the Ethics Commission, whether they are just going to take our request for enforcement as is, because I thought that they were not going to re-adjudicate our cases. They were just going to take it as is, as for enforcement, or are they able to go a step further on their own? That's what I would like an answer about.
Okay, so quickly, the answer to that is because this body, the Sunshine Ordinance Task Force, does not have enforcement authority, according to them, in their view, our orders of determination are not legal findings of facts or conclusion of law. They consider what we do to be just a public investigation for findings, much like their internal investigatory body. So in the Ethics Commission, in their procedure, what we do here, they do in secret with investigators. Okay, and whatever the results of that investigation is gets presented to the body for enforcement. That enforcement, because they could take away people's or penalize them or take away personal property, that has certain adjudicatory weight, and so they will take our order of determination or our referral much like a recommendation. Okay, and they will look at the facts. They will run it through probably their investigatory department as it is, and will, in their particular filters or however they do things, will come out with a recommendation to the Ethics Commission. They did say that they would give deference to some extent of the work that we've done here. If they find that there is something missing or something that they disagree with, that they will return it back to us, that they won't wholesale just overarch it. So that's the only assurance that we have.
So, I mean, that makes me think two things. I mean, it looks like this motion is going to be headed for failure, and I still think we're going to vote on it anyways because I know where Member Fisher stands. It's my inclination to include the language of asking them to examine for willful failure, but I would like to hear thoughts from the other members of the task force.
Member testify.
So on this matter, I know that we have seen a similar case, and I just kind of don't know where this is going to end, and that is why I am inclined to support the motion from Member Moss, at least to get us some kind of closure and get the public and parties out there knowing how this matter is going to be handled in the future so that we don't keep hearing the same complaint on the same issue over and over again. So, we have our workload. We have a lot of complaints that come in, and where we can get some resolution so that people don't have to keep filing the same complaint, I would like to just support this motion.
Okay. Any other discussion? Seeing none.
All right, well, so then I would have my motion be that we refer this to the Ethics Commission for enforcement and ask them to examine this case in context under 6734.
Okay. The seconder?
Yes.
Agree? Okay. Public comment on this motion? No, because this is specific to your case. So is there any other public comment? Seeing no other public comment.
Check.
One moment.
No, just checking if he wants to comment.
Okay. No more public comment. Please call roll.
On that motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Highland, excuse. Elding, excuse. Josh Wolf, recuse. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Chair Wolf.
Aye.
Wolf, aye. The motion fails.
Motion fails.
Yeah.
It's a vote of
5-1.
Oh, 5. Oh, I'm sorry. Yeah. Okay. Motion fails. Okay. So, what?
Can I make, through the chair?
Go ahead.
I'm just wondering, Member Fisher, if, and I don't know if we can do this. Can this?
I'm not going to answer you. Whatever you're going to ask.
I was just
go
going to
ahead.
say, if this goes to compliance and amendments, requesting that Supervisor Breed provide this information, and if they again don't show up, would you consider this motion?
I'd consider it. Let's see how it goes.
Would you like for me to refer it to CAC?
I think that's the only.
I'm not inflexible.
I think that's the only way we
Okay.
might get the information from
All right.
Mr. Petrellis.
So I'll refer this to CAC.
Am I on that?
Okay.
Victor? Am I on that committee?
All right. No more discussion on this matter.
We missed
Okay.
you terribly.
Please call the next item.
Next on the agenda, item number 4, file number 17089, complaint filed by Anthropo against Kate Patterson and the Arts Commission for allegedly violating Administrative Code Section 67.25 by failing to respond to a immediate disclosure request in a timely and/or complete manner. On August 22nd, the complaint committee determined that the task force has jurisdiction and referred the matter to the task force for hearing.
Okay.
Hi.
Mr. Bowe, 5 minutes.
Hi. Firstly, I want to say that the HBO movie Shouting Fire, Stories from the Edge of Free Speech showed a small portion of member Josh Wolf, which I was surprised to see. It's on HBO. Okay, so this complaint, you see the timeline on page 29, which goes almost day by day. basically, I asked for documents. I didn't get the documents. I wasn't told which documents they had, which ones they didn't. I went out of my way, went to the clerk's office and looked at the file, and there were no documents in the file either. And it didn't appear to me that Ann Trickey even made an attempt to respond to this. The original IDR sent August 1st, request all interdepartmental emails concerning a statement made by Ann Trickey today, August 1st. The Arts Commission is investigating your application. Request what's under investigation, those would be written documents. Request the content of the investigation, who's conducting it, and all investigative notes. So by August 4th, when the complaint was filed, I believe, by that, what you see from page 38, which is a timeline again, page 45 begin all of the files and paperwork which were available. Included were investigative notes, who's done the investigation, and so if this investigation is ongoing, then the document should have been supplied on a rolling basis. Instead, at this time, we have no records responsive to your request. So the way I see it, these documents go until page 128. It's a sizable amount of documents that the Arts Commission had. They could have turned over on a rolling basis, or could have kept me up to date. Instead, they didn't even cite a section in the code, which makes it really strange. So the formal Sunshine complaint was against Ann Trickey because that's where I sent the email to. Kate Patterson is the custodian of records. No, I sent the email to Rebecca Krill. So in a typical fashion, Kate Patterson spends about 30 seconds on due diligence before I get it. This is a pattern, it's constant, before I get a response saying we don't have any records. And I suggest to you that her personal website, SF Artful Living, she spends a lot more time at that than she spends on Sunshine complaints. A lot of the postings done during office hours. You see some of the dates and times. I don't know how much time was spent on this thing, but not very much. There were documents available. Instead, I got some kind of running dialogue of something, my attempts to find out stuff. So these are of her personal website and during office hours.
Victor, you switch to the overhead.
Anyway.
Sorry, we can't see it quite yet.
No, sorry.
Victor, is the screen broken?
These are the dates and times of her postings. Here you see one, Friday, April 14th, 12:12. October 5th, 3:49. October 5, 8:52. September 22nd, 11:40.
Actually, can you center it? We can't.
It's kind of irrelevant to the Sunshine complaint. It's just a comment that I should make, saying that she obviously spends more time at her personal blog during office hours than she spends on Sunshine requests.
Sorry, Member Wolf, this doesn't feel much different than somebody handing us a piece of paper from something that wasn't included in the packet.
I only just found out about it.
Okay, so disregard it.
So there are multiple violations. Failure to even respond to the IDR, citing which documents they had, which ones they didn't, which ones they were going to send in a redacted form, failure to cite codes, sunshine codes would be nice, failure to supply the documents on a rolling basis. As we've already explained to you in an email,
Time has expired.
I'm sorry.
It's okay.
Okay.
Any persons or witnesses provide any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent? Somebody from the Arts Commission?
Yeah.
Okay. Please state your name for the record.
Good afternoon, Rebecca Krell, representing the Arts Commission. So I'm going to read our response for the public record in your packet, dated August 4th, 2017. Dear Mr. Young, the complaint of file number 17089 alleges that the Arts Commission violated Administrative Code, Sunshine Ordinance, Section 67.25, for failing to respond to an immediate disclosure request in a timely or complete manner. The Arts Commission sent Ms. Chabot an email on July 14th, 2017, indicating we had received an application and that it was under investigation. Ms. Chabot submitted a second application on July 17th, 2017, when the street artist's office was closed. The Arts Commission confirmed receipt of this application on July 18th, 2017, and reiterated that the application was under investigation. On July 20th, 2017, in response to an email from Ms. Chabot, the Arts Commission again responded that the application was under investigation. On July 24th, Ms. Chabot again sent an email asking about the status of her application. On July 25th at 9:21 a.m., the Arts Commission responded indicating it was still under investigation. Between 12:30 and 12:57 on July 25th, Ms. Chabot came to the street artist's office twice to ask about the status of her application, to which Ms. Trickey responded that it was still under investigation. When Ms. Chabot asked for details, Ms. Trickey responded that the office had been recommended by the city attorney's office to not discuss the details of the investigation. Ms. Chabot asked if that city attorney was Margaret Baumgartner, and Ms. Trickey nodded affirmative. Ms. Chabot sent her follow-up IDR at 3:37 p.m. stating request all interoffice emails between DCA Margaret Baumgartner and SFAC staff concerning, quote, orders issued by Baumgartner not to process a street artist permit submitted by Anne Chabot, end quote. This was a taped statement made on July 25th by Anne Trickey. On July 26th, the Arts Commission responded to her IDR and informed her that we were withholding records subject to attorney-client privilege. We did provide the legal justification for withholding the documents. On July 31st, Ms. Chabot sent another email asking about the status of her application. On August 1st at 11:45 a.m., she came to the Arts Commission office to discuss the status with market manager Anne Trickey, who informed her again that it was still under investigation. At 3:53, Ms. Chabot sent an IDR stating, request what is under investigation, request the content of this investigation, who is conducting it, and all investigative notes as of August 1st. Kate Patterson responded at 4:03 p.m., stating we had already responded to her request for this same information on July 26th. On August 3rd, the Arts Commission sent Ms. Chabot an email informing her that her application had been denied. Please find attached all email communication mentioned, as well as the letter indicating Ms. Chabot's application was denied. At every step of this process, the Arts Commission has responded within the time required and with the information requested. Therefore, we believe there to be no violation. And that was authored by our Director of Communications, Kate Patterson.
Okay, thank you. Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members? Time for questions, clarifications from either party. Okay, I have a few, Ms. Krell. So was the 714 request different from the 720 request, or was that just a reissue of the same?
The 714 I believe 714 was an email we sent confirming receipt of an application.
Oh, I'm sorry. It would be 714 and 717. So you say in your stem, just going by your
a second application. So as a standard operating procedure, when we receive an application, we confirm receipt of it in writing.
This was not a request for information.
That's my understanding. It was just confirming receipt of an application.
I'm sorry. These were applications for a permit?
Correct.
Okay. All right, Ms. Trudeau, can you confirm this?
This is absolutely wrong information.
I just want an answer to the question. They say that there was an email on July 14th indicating that they received an application, and then they said they received a second application. Did you?
No, I did not. In fact, I went to the clerk's office to look at the file, and I found nothing in it. The letter that was just written, this is my first time hearing it. So in response to your question, was there a sunshine complaint filed on August 2nd? Yes.
No, that wasn't my question. My question was, did you make a request, more than one request, and were the requests different? Are we dealing with two different requests here or one request?
On page 24, you see the request.
Okay.
I sent an email to Rebecca Krill on August 1st.
Okay, thank you. That's all I wanted to confirm. Ms. Krill, who does or did the investigation? And, in a general sense, why would there be an investigation? What's the purpose, or how does that come about?
Sure. It was conducted by staff, and it's the result of prior issues regarding the failure of the applicant to list an address where the work was created. So part of the requirements for the street artist license is to provide both a mailing address where the office can communicate with the license holder, and then also if it's a separate location, the location where the work is made. And that's because the ordinance governing the program requires that the work being sold be handmade. It's kind of the crux of the
So is this
program.
An administrative review, an administrative investigation?
It's an administrative investigation.
Okay. And so it's not law enforcement?
In the past, we do work closely with the city attorney because, again, of the issues with this particular case.
That city attorney is not law enforcement?
Correct.
So this is not like a police investigation?
Correct.
Like you did not ask the police department to do this?
No.
Or the sheriff's department or any other?
No.
Okay. Are you claiming that the investigation process is confidential?
Correct.
And is there any codes or ordinances that allows for that?
I'm going to have to check my documents and respond to you about that later.
Because the burden on you is to tell us the purpose for withholding. And just because the city attorney said that you should withhold it because it's under investigation, you have to cite where the law allows for that.
Okay. My understanding is all the communications that we have with the city attorney are subject to privileged confidential information.
That
we have client attorney privilege.
It depends. I mean, we're talking about an investigation that you're having with a member of the public. Okay? We're not talking about discussions you're having with the city attorney. Okay? You're claiming not to whatever advice that you got from the city attorney is not what I'm asking about. Your decision based upon that and whatever other advice that you were getting is what I'm asking about. So, because that's what's here. That's why we're here. Okay, you ultimately, from whatever information that you got and decisions that you made to withhold the information, and you're citing that it was because it was under investigation. And I'm just asking, under what authority can you withhold that information? If there is some authority, some statute that says that, fine. That helps us.
Okay.
So if it was like in a police investigation, and they're in the middle of a police investigation, there's police code, there is lots of codes that protect an investigation from releasing information during the investigation. Once the investigation is over, it can be released after that. So that's what I'm inquiring about.
Okay, I'll have to find more information and get back to you on that.
Okay, thank you very much. Members, any other questions? Seeing none, should we move to rebuttals? Okay. If you have any rebuttals, you're first for rebuttals.
Mm.
No, I do not.
Okay, great. Mr. Bowe?
The so-called investigation is a matter of public record. Board of Appeal number 17131, which is in your packet. The investigation done by Ann Trickey on the public record was she did a Google map search, found that 129 East 60th Street, New York, 10022, in her mind is a Japanese restaurant, and I live there. It's not a Japanese restaurant. I showed at the hearing, block and lot, tax records, and so it's a 5-story landmark building. Then she claimed in a Google search map, Market and Spear, a photo of me selling commercial goods from a table. I spent 3 days blowing up this Google map search photo, and there was only a flower stand there. There was absolutely nothing else. So it's constant misinformation, shifting, changing. She claimed to have gone to Union Square Park, didn't state date, time, who she spoke to, but she didn't find me there. That was her investigation. So she certainly should have taken notes. She should have said, I spoke to this person at this date and time. I spent so much time fooling around with Google Maps. Whatever. Her story changed then that it was a French restaurant and that my name wasn't on the mailbox. And I mean, it just went on and on. So I was very clear in my IDR. There were responsive records. You saw the voluminous amount of the responsive records. They are not covered by attorney-client privilege on this because Ann Trickey was the one who did it. And all they detailed was my attempts to try to get information. There were other people, too, who called to try and find out. Cynthia Goldstein from the Board of Appeals, because that application languished for 8 months without being acted on. A lot of people called. They were basically not referred out anywhere. They didn't get any information, and nobody knew what was going on. So what I see are multiple violations here. And Rebecca Krill was not at that hearing.
Thank you. Hold on, I'm just trying to find something. Oh, here it is. Just for clarification, Ms. Trabo, was this an IDR?
Was it an IDR?
Yeah, or was it just a standard request of information?
No, it was an IDR. You see the original one on page 25 of your packet. August 1st at 3:53.
Yes, okay, thank you.
Okay.
Okay. Members, is there a motion? I'll ask again, is there a motion?
I mean,
Member Canada.
after all of the rhetoric, we went through so many timelines. It seems to me we're dealing with one IDR, the one of August 1st. And the response to that was that we're not giving you anything because there's an ongoing investigation, but the Arts Commission has not provided any legal code to withhold this. It's not a police investigation. So, I mean, they did respond on the same day, August 1st, so it's not a timely issue. It's just an issue of not providing data. So that would be 6721. I don't know which. E.
Sorry, the failure or?
6721D, if custodian refuses, fails to comply, or incompletely complies with the request.
Okay. Is that a motion?
So I would move that as a motion, yeah, to find that violation.
So there's that. This was also an IDR, so it would be in violation of 6725.
But my understanding is they responded that same day saying that we already, as we told you before, we're not giving you records because of the investigation. And that was done on the same day, August 1st.
Okay. Fair enough. Okay, is there a second?
Sorry, I didn't catch the entirety of that motion.
It's just violation 6721E.
For failure to...
D.
D.
D, correct, I'm sorry.
Is there a second for that?
Is there a second? I'll second it. And just for the record, I would like the record to show that this was because the respondent didn't provide a statute that authorized the withholding. Okay. Any discussion on the motion? Seeing none, public comment. Any public comment on the motion? Seeing no public comment, please call the roll.
On that motion, Member Kanata.
Aye.
Kanata, aye. Member Moss.
Aye.
Moss, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Highland, excuse. Eldon, excuse. Member Josh Wolf.
Aye.
Wolf, aye. Member Tesfa.
Aye.
Tesfa, aye. Copra, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. Please call for public comment.
Yes. Next on the agenda, item 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Members of the
Public comment.
public comment. I would like to address the issue of Article 24 of the San Francisco Police Code, which mandates the street artist program. Rebecca Krill is misinformed. It says simply the applicant should provide a residence address, a name, and contact information of a person in case of emergency. It does not require additional information as stated by Rebecca Krill.
Any other public comment?
Hello, Michael Petrellis again. I would like to again advocate for these monthly meetings to air on SF Gov TV. I am very disappointed with all members of the Board of Supervisors over the years, whether they're progressive, moderates, radicals, conservatives, however they want to identify themselves. The fact that none of them, as far as I know, have stepped forward to say we need to find the funding to air Sunshine meetings on TV is a blot of shame on every supervisor's record. I'd like to point out there's a gentleman in the audience here who has brought his own mobile studio of recording audio and tape equipment, and I hope we find out where he's going to be sharing whatever he's recording, because I'll certainly use my social media to publicize whatever he tapes and records from here. And lastly, I hope that this body will send an inquiry in writing to the city attorney to find out why there was no assistant city attorney here 2 months ago, and what they will do in the future to guarantee that a representative of the city attorney's office is sitting in that chair. Thank you.
Any other public comment? Seeing no public comment is closed. Please call next item.
Next on the agenda is item number 5, file number 17028, complaint filed by Anthropo against Kate Patterson and Arts Commission for allegedly violating Administrative Code Section 67.25, 67.26, and 67.27 by failing to respond to immediate disclosure requests in a complete manner.
Is there any summary?
Yes. This was heard by the Complaint Committee on September 26, 2017. Mr. Rowe at that meeting disputed the code citation used by the Arts Commission to justify the withholding of records. I believe that the Arts Commission stated that Mr. Poe had submitted the same request up to 6 times previously, and the Arts Commission has responded on multiple occasions. Ms. Patterson stated that pursuant to California Government Code Section 6754C and K, California Evidence Code 1041, and the advice provided by the Office of the City Attorney, the Arts Commission will not release protected records. Ms. Patterson stated that the Arts Commission responded in a timely manner and has responded to the same request on multiple occasions.
Thank you. Mr. Poe, 5 minutes.
No, I actually listened to the audio prior to coming here. Kate Patterson did not say all that. She just said the city attorney gave us the codes. Well, the codes were wrong, and I've included them in my file. The face page on the agenda packet lists Board of Supervisors request for proposal. That has nothing to do with this file. And the previous files, 15154, 16083, 17026, cite the same codes. I just didn't bother to look them up. So this time I did. And on page 138, I sent an IDR email in the subject line on April 10th. And what she responded is, we've already said we don't have to respond to you. We don't have to supply you records that we feel jeopardize the safety of our staff and commissioners. Well, it seems that she's internalized this and she's decided on her own that's the way she feels about it. She probably didn't consult anybody. I'm still not understanding why I got that email, which was unsolicited in the first place. It was a memo for future interactions with the Arts Commission. Came out of nowhere, and it intrigued me. It seemed vague. There was no reference to anything, no dates and times, tones of emails that they felt were abusive, and it seemed extremely subjective, so I wanted to know information. What are you basing this on? Please send me documents. She doesn't have to, because we feel it jeopardizes the safety of our staff and commissioners. I don't know. It would seem to me if I've done things even smallly relevant to that, she might refer me to the police department or refer me to the city attorney's office or something. I mean, I would think so. And then she doesn't want to engage in a back and forth, but she does it all the time. It bounced back because she had soft. Don't know what it means. So, as I said, this memo for future interactions lacks evidence to support her claims, and I highlighted the portions of the emails that all documents, police report, written correspondence that supports claims listed in the unsolicited emails. The code she cites, California Government Code 6254C, personal, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of privacy. I don't know what that has to do with anything. Government Code 6254K, records, the disclosure of which is exempted or prohibited pursuant to the federal or state law, including but not limited to provisions of the Evidence Code relating to privilege. Government Code 627632 pertains to narcotics. I've included all the codes here. And there's certain things with the California Evidence Code, which mainly are in criminal matters to protect somebody testifying on the stand. That would be law enforcement, a Crime Stopper organization, not even having to do with an individual, and certainly not having to do with this email. So once again, I don't know which documents they have, which ones they don't, which are provided on a rolling basis, which are redacted, which aren't. It's just another one of those vague things that you don't understand. So page 182 is the email in question. We are deeply alarmed by my behavior. What kind of behavior? What are we talking about? What did I do? We are writing today to notify you that we will no longer engage in back and forth. Well, that's what she constantly does, and that's why these Arts Commission files sometimes exceed 2,000 pages. The duplicate, the half sentences, I have no idea what she's talking about most of the time. We will no longer engage with back and forth communication with you when we feel that you're being aggressive and menacing. Well, let's see some instances of that. I would think there would be police reports. There would be dates and times if I've done these things. Let's get some details about that. We will not engage in any further dialogue that extends beyond basic communication. Well, this was a simple IDR. It would have taken 10 minutes to fulfill. I never ask questions because I know interrogatories are not part of the Sunshine Ordinance. Probably she doesn't. Offices may limit responses to the extent that the law requires. What does that mean? She doesn't even know what the law is. Furthermore, we will not tolerate threats, insulting language in our workplace. When did I ever do that? I would like to know. At commission meetings, public comment is public comment. We all know it's politically protected free speech. This is a formal place of business. If you want us to assist you, you must maintain proper conduct at all times. I think I was in that office once. So I'm confused. I don't know what's going on here. And this thing came out of nowhere. I think it would be confusing to anybody to read it, much less to see it now, almost a year later.
Thank you. Any persons or witnesses on behalf of the complainant, petitioner, provide any additional facts or evidence? Seeing none, respondent?
Rebecca Krell, representing the Arts Commission. I'm going to again read from our response authored by Communications Director Kate Patterson. I'm just going to read a portion of this. We denied her request, citing California Government Codes 6254C and K and 6276.32, California Evidence Code 1041. The same request for documents that illustrate her harassment of staff and commissioners has been made and brought forth to the Sunshine Task Force 4 separate times. File numbers 15154, 16008, 16083, 17026, and most recently 17026. Oh, it's the same one. In every instance, the task force found in favor of the Arts Commission, as we have provided ample legal justification for withholding these documents. I believe a very similar issue also went to the Ethics Commission and was ruled in our favor. I don't have any final comments on this.
Okay.
Can take any questions you have. Yeah.
Okay, thank you. Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members? Member Moss? Member...
So, sorry, were you calling on me or?
Calling you first.
Okay.
Yeah.
So, this one is difficult because the thing that kicks this off is allegations of verbal abuse, and I was looking through the code of conduct that we signed when we came onto this committee, and we have an obligation to deal or to not tolerate verbal abuse or attacks on people, and we have to respond to it. And so my preference here would just be to see this work through whatever city process there is for handling these kinds of allegations, and then revisit the case once that has been settled, because it seems weird to me for us to just jump in the middle of something that seems to be brewing within a city department that isn't outside of our area. And I would also not like to see the Sunshine Ordinance become a tool in such a battle that seems to stymie it. I mean, I don't exactly know how to address these issues because they've not come before us before, the issue of our code of conduct and the issue of allegations of abuse, but they're made here in these documents that we're looking at.
You can ask our legal counsel if there's a process and what we might,
I will pose it
to
to our legal counsel as well as our administrator in case they know how these are handled.
You want to take a moment to think about it, and I'll move to Member Wolf. Come back to you. Yeah. Okay.
It's not an area of expertise that I have.
Okay.
So, in listening to the reasons cited to deny the records request, I'm a little confused about 6254C, and that line cites. I'll go ahead and ask both of you this question as we get to the end of it. But that line cites personnel, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of personal privacy. I'm not sure whether it's disclosing the complainant's personal privacy that is of issue, or because there doesn't appear to be any personnel files related to the request, because Ms. Trabeau did not work for the department. Go ahead.
What's plausible is that it may be employees at the Arts Commission who make complaints regarding issues that they have with other staff or members of the public or just general workplace grievances. And if those may have been responsive to a request, those are subject to personnel privacy exemptions.
But they should state that then. They should state that that's the reason for withholding.
If they state the applicable code section that they're withholding documents under, I think that's sufficient under the code.
But we don't know what documents that they're withholding. They're not stating that they're personnel records. They're just citing the statute.
There are also
as a blanket for any and all documents. I would ask them to qualify that. That would be my question.
Going beyond that, there's at least one other reason that's tied together, and it's not clear what documents pertain to what reason and why. And so I guess that's my question for the Arts Commission. Ms. Trabeau, I don't think you can actually help me with that question, but thank you for being there to respond. But if the Arts Commission can speak to what records exist in the generic, because obviously you're not comfortable providing them at this time, and how each of those categories of records falls under specifically what exemption. You sort of grouped your exemption reasons together and said this is why we're not turning this over.
Sure. I think that's because there had been several other instances. I see we enumerate those. It looks like Friday, February 10th, there was an email sent to the committee members enumerating each complaint and the response. I don't want to read the whole thing, but it's in the packet.
I mean, specifically, there was a request for essentially any communication or documents related to what triggered this email about a response to the complainant's communication to you.
Right.
So she has requested any and all documents that led up to that or discussing that. So I don't think the history of Trabeau and your department is really what I'm interested so much is what records exist in categorical terms, not specifically what the content of those records are, And within each given record that does exist related to a request, why can she not have that information?
Right. So it's all the same issue, though, which is why I was bringing up the context. It's all the issue of our right to protect a complainant's privacy. So this is the same issue that continues to come up.
I'm sorry, you're right. Oh, you're not using complainant in regards to
an
Ms.
employee,
Chabot.
right? An employee
to employ acts of the Arts Commission.
Correct.
Filed a complaint that names Ms. Chabot in some constellation, whether,
expressing concerns. Correct.
And so your position is that both the content of that complaint as well as the individuals named in that complaint is all ipso facto protected from disclosure.
Correct. That's our understanding. That's also our understanding based on this memo issued by the city attorney when prior instances of this same issue have come up. And the code of conduct email that we sent, I just wanted to also add that that's based on a code of conduct email that the clerk of the Board of Supervisors issued to Ms. Chabot as well.
Okay, so that's the actual complaints themselves. I imagine it's possible that there could be an evidentiary process of gathering past examples that are in your records. And although I understand that the complaint could trigger it, those existing records that were referenced would be public records outside of this context. Do any such records exist, or is there just the complaint itself? Is there evidence within that complaint file?
Not to my knowledge, but I would have to check that.
Okay. I'm just sort of going through what potential documents would have fallen under Ms. Chabot's initial request to sort of map out why, if they exist, and why they wouldn't have been provided.
Right. So if there's, obviously if there's been a verbal exchange, that there's no documents other than somebody, issuing a formal written complaint that exist.
Right. Of course.
Right.
Anybody else? Yeah, I just am trying to see if I have any other questions. Okay, I'll wait till after rebuttals because it's more procedural. Okay, any other questions or clarifications? Seeing none, let's move to rebuttals. Ms. Grell, do you have any rebuttal? Okay, the respondent declines rebuttal. Ms. Chabot.
What Rebecca Krill is referring to is this Barbara Scalar commissioner case, which was overturned on appeal for lack of evidence. You see it in the initial email, which cites that Commissioner had to go get a restraining order. Actually, I'm the one who constantly does public record searches for the malicious cases that the Arts Commission brings against me, and I notified the Arts Commission that this was a pending matter. So that's the crux of this. You see it in the unsolicited email, memo, future interactions with the Arts Commission. So it was overturned on appeal for procedural reasons. Here, the citations are incorrect and do not pertain to a commissioner. I asked for interdepartmental emails. If they didn't have them, they should have said, or we're going to look, or we're going to refer you to the police department, or we're going to do this or that. Even with that Scalar case, there was no police report. There was no evidence. There was no investigation. There was no transcript. There was nothing. She contradicted herself at hearing. I got the transcript. I wasn't served. There were procedural issues, and that's the crux of this matter. And that's the problem that we're having here. We've all listened to previous complaints where Kate Patterson slanders, personally attacks, comes up with all sorts of nonsense against me as if she personally knows me. I don't know these people. So the codes that were cited were incorrect. The previous 3 other complaints, they cited the same codes, which were incorrect. I just didn't look at them. And I'm left as vague as a year ago when I got this email. I didn't do anything. What evidence do you have? She can't even point to any evidence that they have. She'll have to get back to you on that. This is now a year later, and you can understand how frustrating it is for me, because they're operating under the idea that they don't have to release any documents at all because the city attorney protects them. Well, that's not the case. That's not what's going on here, and that's not what the Sunshine Task Force is about. And then when you have multiple people responding to an IDR, which often happens at the Arts Commission, it gets very convoluted. And that's why those files are as big as they are. That's it. I see violations. I would like to get the documents. I'd like to know what I did.
Thank you. Members? I have an additional question for clarification, Ms. Corral, if you don't mind. And Member Wolf, based upon your last questions, if any of the responses seem you want to chime in on this, I'd appreciate it. So I'm just wondering, are there records? There's been citations of law here stating protections from records or information that the petitioner is requesting.
Yes, staff have put concerns in writing previously.
So there are is writing. Okay.
Correct.
And so there's a couple of ways that goes. For instance, if there is confidential information, but not all the information on the documents is confidential, then the use of redaction is appropriate. And mostly in anything other than something that is held, outside of law enforcement, that's usually the case. I think it's pretty rare outside of law enforcement that an entire compendium of documents, except for personnel records, could be withheld, like completely, like shielded. So I'm wondering, are there any documents that could be provided out of this compendium?
There's not a large compendium of documents. There are a couple of written concerns that are personnel issues.
And if you were to provide those documents and removed and redacted all the names, would that be protection enough?
I would have to look at the document to better know.
Okay, because all records are public records, and so it's a very kind of high bar to withhold the entire record, and that's why, like in the previous case, I had asked if there were any specific, statutes or codes. Here, it's being cited, but we don't quite know what is being cited. Okay, it just seems kind of blanket. And so because I'm not necessarily sure that your internal investigations, unless they're being handled by HR, the city's HR department or some other department that has that kind of jurisdiction to do that, I'm not quite sure that there's much protection for those investigations. So it's kind of an open question for me.
Okay.
And I'd even go further that even if every word on every page of every document is deemed non-disclosable, the amount of content there may be could serve the public's interest or requester's interest. So, for example, if you're looking for a document related to something this doesn't relate to what you guys are doing, and there is no document, but the department responds back that any information would be protected, just getting that document that there is no documents can be meaningful, or getting that blank page that shows that there is a document can be meaningful. The other thing that I'd be curious to see is if the complainant were to request an index of the records that are being denied, that would allow her to see exactly what exists in that file in terms of sort of a descriptive basis, not the actual content. And that would help us to sort of navigate through what may be a legitimate exemption and what might be problematic.
Thank you. Okay, thank you very much.
Thank you.
Okay, any other discussion for the matter? Is there a motion? Are there any concerns about making a motion? Do you need more information? More clarification? No?
I have a
Member Wolf.
procedural question. So I had just suggested to the complainant that she might seek a list of what records are out there. If she were to do so, if we were to not make a ruling on this, or not find a violation today, if she were to move forward and request that, and that proved enlightening, would that require the complainant to make a new file, and would that be a duplicative case, or would she be free to do so?
No, you can request that the item be continued and have them return with that information. They can return back with whatever response there might be. Either they return with exactly what you asked for, or they return without it and some other explanation.
No, I understand that. Okay. That wasn't the question.
Okay.
The question was that if the complainant moves forward and seeks additional information pertaining to this same case that then creates a suggestion that there may in fact be a violation, can they bring it back either as a new file or reopen this file, or is it a duplicative file and rejected because of that?
It would be considered duplicative.
All right, then I would like to make a motion for continuance.
All right.
The call with the chair.
Moved by Member Wolf. Is there a second?
Second that.
Second by Member Tesfaye.
Quick question: do you want them to produce the index that you were referencing?
I mean, I think that's entirely between the parties,
okay.
But it is my concern that if the complainant is able to find more information to suggest there is an evidence of a violation, that she shouldn't be prevented from taking that to...
Well, so the continuance is for the purposes of what? The purpose would be for us. You know, you're asking for a continuance.
The continuance is... So I don't... If the complainant wants to identify information by filing a request about what documents exist in order to open this, she should be free to do so. Personally, I think that she should just be able to reopen the complaint, and we shouldn't have to keep this open through a continuance process. But it seems like that was the most viable suggestion.
The reason why we would do a continuance is because we are missing information or needing something from one or the other parties in order so that we can come to some conclusion. It's not to keep a case open so one or the other parties can continue to, do some work unless we are asking for them to do some specific work.
All right, fine, we'll do it that way. Ms. Trabeau, through the chair, can I ask Ms. Trabeau a question?
Yes, you can.
Ms. Trabeau?
Hi.
I put forward a possible way to gather some information by requesting a list of what documents are out there. Is that something you're interested in pursuing, and at what point do you think you'd complete that process if you were interested in doing so?
I have three issues. The first, you've heard from Ms. Krill that yes, there are some concerns, there are I got the idea, a few written documents. So we know something is there. We don't know how many or what, and she hasn't bothered to look. So if you wanted to continue it, it might be to get her to produce these things. And then
I'm not really sure it's within my prerogative to compel her to produce those
Yes,
things.
it is, absolutely.
That's what we do
Any
here.
authority that we have under 6721.
But it's outside of the actual scope of her original request.
All interdepartment emails and written documents. She's admitted to having written documents.
They're claiming, hold on a second, Ms. Chabot. They're claiming to withhold all the information that the requester has asked based upon the section of code.
Okay.
You specifically asked for just an index of what records may exist.
Right.
Just a listing.
Mm-hmm.
Is that something that you want the respondent to provide to us so that we can, it would provide us with more information as to what those items might be?
That's
or-
yet another approach to this puzzle that was not the way that I was looking.
I would
but
prefer
we can do that way instead.
I would prefer that approach.
I would prefer it that way.
Sure, I was just trying to come up with the easiest way to crack the egg. I don't actually have any more questions for you at this moment, Ms. Chabot, but if...
Can I make a quick comment? They're now using the next request system, and being that Kay Patterson doesn't know how to use it.
Okay, that's not pertinent to this right now.
She doesn't even publish it.
Ms. Chabot, please, Ms. Chabot, let us try to do our work.
I'd like to see the document.
Can you allow it? Thank you. Sorry.
That's okay. So if you want to make part of, let me just help, if I can guide you on this. So if you want to make a request as part of your motion for the respondent to provide something that would help us, close this case, that's fine, and then we can continue it.
That's exactly what I'm...
Go for it.
I have the representative from the Arts Commission. Can please come up? So it seems to me that there is between two and more documents and not a whole lot of documents that pertain to a request, but we have not had a chance to see a listing of what those documents are. How soon would the Arts Commission be able to prepare an index of records listing out any documents that pertain to the complainant's request and a general description of what that document is, which obviously wouldn't contain any exempt information? How long would it take to prepare such a document?
I don't know how long it would take. I do know that we have an extremely long history with Ms. Chabot going back many years. And so there's a file of thousands and thousands of documents. I don't know how long it would take to go through each and determine which is pertinent to this specific request.
Okay. Before the next Sunshine Task Force meeting, would you be able to either provide that index or a date by which you could complete that index?
Sure.
Through Victor?
Sure.
Go ahead, Member
Through the chair,
Canal.
can we also include the code by which, if you're going to have 10 items in this index, the code which would cause that item not to be released?
Okay.
That would be appreciated as well. Thank you. Anything else that people want in this list, document, index? So I would like to make a motion that we continue the item pending the information brought forward from the Arts Commission in order to best move forward on identifying whether or not there's a violation.
Okay.
Second.
So moved by Member Wolf, second by Member
It was
Hensy.
originally seconded by Member Tesfa.
Oh,
Go ahead.
okay. Do you accept that?
I do.
Okay.
And just to clarify, it's a motion to continue the matter to the call of chair with a request to the Arts Commission to provide a description of records in the form of possibly an index of records, along with a quote of which code section they are using as justification to withhold.
Yes.
Okay. To the motion, I just want to pay heed a little bit to how voluminous this might be. And the question is in the request that Ms. Trudeau had made originally, is there some scope or some range? Is it between a certain period of dates? Is it for a particular subject matter, and that kind of thing, so that we're not receiving and they're not doing work that is not pertinent to this
Can
case.
someone point to the page that has the original language of the IDR so that I can...
It's on page 132, I believe, after the lengthy paragraph from the Arts Commission. An IDR was sent to Ms. Patterson, request all documents, emails, police reports, and written correspondence to support the claims listed in the unsolicited email.
The email that I received had no range. They had no date and time. The original memo for future interactions, it was completely vague. And I also want to point out that first you said a few
No, we want to know what the original request was. That's we want to
The original request is exactly what was just pointed out. The issue is that neither one is framed around dates.
That's right.
The Arts Commission is looking at a history with Ms. Trudeau to make their determination, and they did not, in the letter, set what date that window started. And Ms. Trudeau didn't, in turn, set a date other than referring it back to the Arts Commission. So I would be inclined to say that the Arts Commission is tasked with listing all documents that pertain to their action. If they decide that the stuff that happened more than 10 years ago is irrelevant, I think that's legitimate. If they decide that any interaction with Ms. Trudeau going back to the 1980s is appropriate to the reason they sent the letter, then that's all supporting material.
I would ask also if all right, never mind. Not necessary. Okay.
Could I ask for a description of the documents so at least I have some idea? Because they continue to...
That's part of the motion.
Okay.
I mean, I think it is reasonable to ask that what they provide to Victor, they also provide to the complainant.
Yeah, that's a big problem.
I think that's...
I always transmit it once I receive.
Either way.
But they should transmit it directly to me. I shouldn't have to constantly run up to the clerk's office.
It sounds like you'll receive it whether through Victor or the Arts Commission. So,
Okay.
I just have a quick question for Ms. Krell. I don't know whether you know or anybody else knows, if we're talking about years and years and years of stuff, some items may have already been made public.
Right. A lot of them have. I mean, in reading the request, the response to our code of conduct, like one of the allegations in the code of conduct is the back and forth, right? So obviously that's every document. And I know in the past we have turned over entire files of what we have.
Yeah,
so it's going to require some judgment and discretion to determine what explicitly the requester wants to see that she hasn't received before. So I'm going to have to look into that.
Right. I mean, all I'm saying is that if you're citing protection under the government code for these sections for these particular documents, and some, most, all, none have already been publicized. Mm-hmm. There's no protection anymore.
No, I think the protection, again, this was the same issue that came up over and over again, was specifically around a specific individual, a member of staff who had expressed concern and the right to that individual's protection and privacy as a personnel matter. So that's very specific, but obviously this can be interpreted more broadly.
Right, because if the documents have already been publicized, then the protection is not available. It would be for any future. it could be for any future communications, but not the ones that have already been released publicly. Because we've heard, a lot of this might have already come across our desks already.
Mm-hmm.
So, okay. All right, is that it? Anything else for the good of the cause? Yes, Member Moss.
I don't know. I mean, I guess my only thought here is that reading the request as filed, I mean, as it was phrased, doesn't necessarily really specify. It's not very specific in the type of documents. I mean, read broadly, the request is asking for every email exchange ever sent between, the respondent and the complainant forever. And I'm not sure that is narrow enough to get an answer that actually helps anybody.
Yeah, I hear you. The other caveat I would add to that also is just whether this reason for citing these codes as part of protection is actually an appropriate use of that section. The question of protection in some kind of way is protection from what? And, if there's some active, some active areas of retaliation or anything like that, that could be cited for that. And frankly, I think, because you're just an administrative body and not a law enforcement body, if you had like a letter or a memo from the DA or something, or even from the city attorney that said, this is a legal, kind of case involving this, that, and the other thing, that helps us also make that kind of decision. I'm not saying do that or don't do that, but in general, that would be something that, because it's a kind of a high bar, to cite a blanket protection in that kind of way. Member Wolf, then Member Moss.
In response to what Member Moss said, it seems to me that when the initial request came through, the Arts Commission would have gone through, identified what documents they felt they had in their possession that met the criterion of the request, and then gone through the process of identifying which of those documents could be disclosed, which they at the time determined was none. Now, I'm essentially asking them to rewind the clock to when they put all the documents together on the table and said, you can't get any of these, and give us a list of what those documents are.
I understand that. I think that the discussion about whether the exemptions were properly cited is probably the case here. I find that very compelling and interesting. I'm just not sure about asking them to categorize all of the documents they have. I mean, I think about it if I had made a claim during the committee that I said, I think that climate change is a problem, and then somebody said, I want all records that you've ever seen that have convinced you that climate change is a problem, I couldn't fulfill that request. There's just too much out there that I've just consumed in life to be able to go and say what.
But this isn't general. This isn't general information. This is between two parties that are known.
True, but I mean the way that this is phrased is it says to support the claims below, and there's not necessarily. I mean the way the first paragraph says. We have always been cordial and professional responses to your multiple complaints and emails, and so the fact that they reference in their email complaints and emails then somehow implies that if the request is all emails that support your claim, and the original letter is we are talking about the entire history of our communications together. It just doesn't seem like this is like they're going to have to go and sit and review every single document ever cross between them two.
Well, go ahead, member, testify.
And to Mr. Moss's point, I think that the difference between, or I think you're making an important point, because it's not like they have created a public policy against this individual, or, in the example that you gave on climate change, if the agency or whomever had created a policy, saying because we believe climate change exists, we're going to do X, Y, and Z, then you could say, well, then, what evidence do you have of that being true? What did you base your decision on? And in this case, it's, proof to support a correspondence. And it's not a policy that this agency has put out against this individual, and she's asking, what support is there for this public policy. So I think we need to maybe have some more constraints about or limitations to kind of hone in what we're asking for.
So do
To
you
address
want
his concern.
So, I mean, are you asking for a particular time period that this would have begun? Because, you know, this particular, whatever the respondent was asking for sounds like it was a particular, I mean, not the respondent, the petitioner was asking for was for a specific incident. So when did that incident begin? That kind of thing. Would it be more appropriate to ask for, you know, like from this point to the present?
I mean, if the incident has to do with the rejection of her application, then incidents that support the rejection of the application. But I think it needs to be tied to some type of action taken by this body, that agency, department, whatever.
Member Wolf?
If the request was too vague for the commission to identify what records would fall within it, that needs to be a conversation that happens between the requester and the responding department. Instead of saying, we don't know what you're asking for, they said, we have records and they're exempt under these reasons. All I'm asking for is whatever records they identified in the process of identifying what records they had in response to the original request, that they list those out so that we can rationally walk through how they do or don't qualify as legitimate exemptions. So I think that if we, as this party, set some arbitrary timeline on it, we're sort of interfering in what's supposed to be a negotiation between the two parties about what they're actually asking for in the first place.
My suggestion wasn't a timeline, but the documents would need to be around some kind of action taken by the organization. I never stated a timeline.
I wasn't trying to put words in your mouth. I believe Chair Wolf had, at some level, suggested a timeline.
Yeah, or some scope. I mean, I don't think it's an appropriate use of time for anyone to go through thousands of records like that, and it's kind of almost needle in a haystack kind of thing, even to find out which documents are applicable unless there is some specific scope. I think if we're going to ask and compel for information to be provided, that we be somewhat specific as to what that is.
But I think the scope should be defined as the records that they previously identified and said are...
Okay. Good. Can we make that explicit in the motion?
That's fine by me.
Okay. Does that sound okay to folks? The seconder?
It sounds good to me if I could just hear it restated.
Okay.
Okay. Of the documents identified in the previous request as existing and non-disclosable, please provide an index of each and every one of those records and what reason specifically each record itemized is non-disclosable.
Okay.
Okay, I can agree with
Does the seconder accept that?
Yes.
Okay. The seconder accepted that. Okay. Let's move to public comment. Is there any public comment on the motion? Seeing no public comment, please call the roll.
On that motion, Member Josh Wolf.
Aye.
Wolf, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Highland, excuse. Eldon, excuse. Copra, absent. Member Moss.
Aye.
Moss, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Is there a date when this...
It was continued to the call of the chair.
Continue to call the chair.
Can I just make one short comment?
No. We want to move on with our agenda.
Simply stating...
Oh, she said no.
They have it...
Mr. Bowe. Mr.
No.
Bowe.
Please. Please call in the next item.
Next on the agenda, item number 7, file number 17129, complaint filed by Patrick Roddy against the Department of Public Health for allegedly violating Administrative Code Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. This matter was heard by the Complaint Committee on January 23, 2018.
Yeah, thank you for getting that in so quickly. That was just 2 weeks ago.
Okay.
Yes.
Great.
Would you like me? I believe that Member Fisher and Member Hinsey were present.
Right.
Yeah.
Would you like me to provide a summary, or would you like to do that?
I would like that. That's up to you, Member Hinsey.
Yeah. Yeah. If I remember anything supplemental. If I remember anything supplemental to your summary, I'll.
Through the chair, you know we will add to it when you're done, so go.
Yes. At that meeting, Mr. Roddy summarized that the reason for his records request and stated that if the department has access to public records held by other organizations, they must retrieve and provide them. At that meeting, the Department of Public Health stated that the department is unable to and are not required to create records or reports. Are not required to create records or reports. The Department of Public Health did contact the State Department of Public Health, and they were informed that requests for the type of information should be submitted directly to the California Department of Public Health, and that the city's Department of Public Health is not in possession of the records, and it's in the possession of the state.
Through the chair, can I add a sentence or two?
Go ahead.
So this was very interesting, notwithstanding the fact that what Dr. Roddy is doing is actually really, really interesting, but that's not Mr. Roddy is doing is very interesting, but that's not relevant. What was relevant is the nuance of this, and we wanted to have DCA Cola here to comment on this, is two things were going on. One, there was, the first thing that popped up in my head was, well, that record doesn't exist. We have to create a report, and that's not part of the Sunshine Ordinance. So there is no creating of a report. So we were kind of like, what does that mean? The other side to this is we were told by the city, we're not allowed to give you that information, but the state is. So that's all I have to say.
And I think Victor, we recommended no violation. Did we?
Yes, the recommendation was to find no violation from the committee.
I think we came to that conclusion because we thought that these were state records, and that, although not to say that Mr. Roddy didn't do the right thing by following his local process, but we determined that it was state records and that it didn't fall under.
And we sort of, I'm sorry, you done, Member Hinsey?
Yeah.
We wanted him to have his, quote, day in court here because while Member Hinsey and I were unpacking it, we weren't 100% sure, and we wanted, again, Mr. Roddy to come up here and state his case with DCA Cola here and the rest of the team here that might have a little more input.
Yeah.
I am really done now.
Yeah.
Okay, great. Then let's have the complainant petitioner come forward. You have 5 minutes, sir.
Thank you, and thanks for letting me do all the camera stuff here as well. Like I said, my name is Patrick Roddy. I am a geoengineering researcher and activist, and I am trying to find out how many San Franciscans have been killed by the spraying in the skies. Alzheimer's has risen 135-fold since this started. So I just wanted to drill down and find out, are there increases on heavy spray days? So, expecting some pushback, I, on August 22nd, asked them for the existence of records. How many records are there for each of these days? That does not violate HIPAA. I'm not asking for names. I'm not asking for nothing. I'm just asking, did someone die? And I am told by the custodian of record of the Department of Public Health, which houses the Vital Statistics Department, that no, we can't tell you if anybody died. When there is foul play, you must be able to access death records. If there was an Ebola outbreak, you'd need to know. We have the CDC who wait 23 months to report any deaths. I think we should have access to deaths. I mean, I was a newspaper reporter, and you'd call up the cops and say, "Oh yeah, what happened?" And they say, "Oh, so and so died. There was a car wreck." Deaths are not state secrets. They must not be. And I find it really quite disgusting, frankly, that the Department of Public Health, which used to house and store death records, is hiding behind this subsection, 102330 section 2, which says comprehensive records are confidential. I'm not asking for comprehensive records in either of these things. First, I asked for how many there are, and then I asked for a subsection. And in the second one, I asked for 8 fields, and on a California death certificate, there's 40 fields. It is not comprehensive. I looked up comprehensive in Black's Law. It's not there. So Merriam-Webster, comprehensive says, covering completely or broadly. The first one is not at all, frankly. I'm just asking them, how many records are there? And they'll say, oh, but that's owned by the state. Well, we employ the Department of Public Health to transmit data on city property to the state. And that's secret? I'm baffled. I'm doing this for the health of everyone in San Francisco and, by extent, the world. We're under assault, and the fact that they will not even admit if anybody died. Why do we have a public health department? What's the Department of Vital Statistics or the Division of Vital Statistics even doing there? And what is the custodian of public record doing? Apart from stonewalling and blocking every move. Why is this such a secret? If there is an epidemic, that's in the public interest. Also, in reading I haven't even been told if any of these records are exempt from disclosure. Any part of them, the existence of the record is that confidential? I have one of my favorite parts of the Sunshine Ordinance is section 67.36. The provisions of this Sunshine Ordinance supersede other local laws. Whenever a conflict in local law is identified, the requirement which would result in greater or more expedited public access to public information shall apply. And the state law is ambiguously written. It does not specify what comprehensive is. It says the indices. The indices cover every county in the state, Riverside, LA, Shasta. I'm not asking for that. I'm just looking for stuff in San Francisco. So it's, clearly we should be told if anybody died. So that's the least I would ask. So thank you.
Are there any persons or witnesses providing any facts or evidence on behalf of the complainant, the petitioner? Seeing none, respondent? Is the respondent present? Thank you.
Good evening, members of the Sunshine Ordinance Task Force. My name is Linda Acosta. I work for the Public Health Department. And I have been told by the California Department of Public Health that I am not allowed to give these records out, and I can read you what they wrote to me. According to Health and Safety Code 102230, Section 2, the birth, death, and marriage record indices prepared pursuant to Paragraph 1 and all comprehensive birth, death, and marriage record indices prepared or maintained by local registrars and county recorders shall be kept confidential and shall be exempt from disclosure under the California Public Records Act. Please defer to your legal counsel regarding your response. Here's a link to our applications below. So they would have a link where people can get this information. So that's typically where researchers go to get this data. So yes, it's available, but I, as San Francisco, am not allowed to give it out. I have a graphic. I'm not sure how this overhead thing works.
Is it in our? Was it submitted for the record?
No. Okay. Basically, it shows that it's not our database and that only the California Department of Public Health is able to give data out.
Question. I mean, in the 6 years I've been here, people have shown graphics. Mr. Hartz would come up and show these funny cartoons and stuff. When did this rule change that we can't put things up?
If it's pertinent to the evidence of the case, what Mr. Hartz does is just list the number of cases that he has brought before us. It's not necessarily.
No, he's also shown us graphics of things that happened.
It
or
usually
something.
isn't contained in the record. It's in our packet. So
Okay.
he's just highlighting what's already in the packet. So because there may be 100 pages or so. If you want to be able to enter it in, the purpose is if it's a piece of information that could change the course of the case.
I don't think it is.
But you don't know that. We haven't seen it yet. We don't know what it is. But if the petitioner, if the complainant hasn't had an opportunity to see it, and it might change the whole course of the case, then that's not fair to the petitioner or any other party, even if the petitioner brought something forward. Everybody has a right to be able to discovery and to have some time to prepare. So if this, for some reason, that happens, now what we could do is we can have Ms. Costa show.
Yeah, I think you're going down a whole other path. I think Mr. Roddy has already seen this. We're the only ones who haven't seen it.
He's shaking his head no. So I don't want to assume anything. If you want to see this document, the best way to deal with it, and this is the way the task force has done it before, is to have whichever party wants to present the document to the other party. If the other party says this is innocuous, doesn't change my case at all, fine. If it does, then we cannot accept it as part of the case.
Chair Wolf, again, I think you're going down a whole different path than I'm going. So what I'm getting at here is, I believe I totally forgot your name. Costa said, blah, 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 we refer people, and there's a link. And now I'm hearing that Mr. Roddy does not have that information. I mean, this reminds me of the case with the coroner, where the coroner said, we have this information, and the complainant said, I don't have it, and the two of them went in the back room and they gave it to each other, and they were done. So it sounds like you're saying there's something available and you don't have it.
No, she wants to put something on the overhead.
That is going to give Mr. Roddy information. No.
It was actually a different graphic that shows that the California Department of Public Health owns that database. That's all it is.
And doesn't it also say, for further information, contact blah, blah, blah?
Yeah, but that's one piece of what's on that paper or that document. What about all the rest of the content on that document?
I'm just trying to get him what he needs.
So I've met.
Why we're all here.
Can I say something? I've met with Mr. Roddy, and he has the link. We sat down, and I gave him the application. I printed it out for him. I said it is available, but this is the process you got to go through.
It's not our practice to introduce new information that's not in our packet that might have an effect on one of the other parties.
It's not a great graphic, anyway.
Okay. The question, it's just because none of us know what, besides the folks that were at the committee, none of us have seen this. So we want to protect everybody and make sure that everybody has a fair chance. That's all. Okay.
Throwing out the baby with the bathwater, but okay.
Continue. Is there anything else you?
Yeah, I can't give that information out. This is, I think, our fourth time here for this, so really I wish I could give it out, but I can't.
Okay.
Thank you.
Very good. Thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing the members.
Yeah, I have a quick question through the chair to Victor. How is this fourth time? I thought this was only the second time we've heard this.
I believe it was heard. There was an appearance of an agreement between the parties, and the matter was withdrawn. And after that fact, the complaint was refiled.
Okay, but this is only the first time for most people, and only the second time for Member Hinsey and I hearing this. Is that correct?
It's gone before the complaint committee.
Oh, it had. Okay.
3 times
Okay.
in different versions, different file numbers.
Okay. Okay. Thank you.
Member Wolf.
I have a question for the representative from the Department of Public Health.
Ms. Costa.
Ms. Costa? Ms. Acosta or
Yes.
Acosta?
Acosta.
Yes, thank you.
So my brain's having a hard time wrapping around this. So if we can just sort of walk through
Sure.
each of these piece by piece. So earlier you said that the database of life and death records, or maybe just death records, is maintained, and I think you actually said owned by the state of California. Is that
Owned, operated, controlled, all of the above.
However, the data that the city and county of San Francisco sends to the state of California to put in that database doesn't retroactively become the property of the state of California, does it?
We don't ever own that property. So what we do is we go in, and this is, I don't use these records. This is me understanding the process. We go in and we check boxes to say, the coroner's report is here, the physician's report is here, and then it goes to the state.
Okay, but if John Doe dies in San Francisco, let's say of totally natural causes so that we don't get the virtue of having all the coroner reports. So they die age 150, whatever. Does the Department of Public Health make a record at any point that person has died?
If a family member came in and requested a death record, a death certificate, or whoever is able to collect that, they would pay the fee and they could print out that death certificate.
Okay, but if you called a funeral, you have to, if someone dies, you can't just bury them in your backyard. So there's some sort of record. Does the funeral home, if someone dies, I call the funeral home. The funeral home's going to have to tell you that someone died, right? Before they can.
They go into the same database and do their portion, and then we go into the same database and check off that everything's been done.
So the funeral home is engaging with a state database,
yes.
And they're going above the city government's infrastructures. It's never actually passing through San Francisco's possession, that data.
Exactly.
Okay. So, in essence, a lot of this data is never actually in your possession other than by accessing it through the state database, is what you're saying?
Yes.
Okay. So what records, if any, related to deaths other than the state database is in possession of the Department of Public Health?
None.
None. Okay. So the only access point to any of the information that the complainant has requested is through a database owned, maintained, and controlled by the state of California.
Yes.
Great. That's super helpful. It seems like the coroner would have some record of some deaths. Did you suggest that the complainant reach out for whatever records the coroner might have?
From what I understand, the California Department of Public Health is the body that gives out information to researchers. So they are the ones that control data, and there's a process for it. It's very clear application for it. You say what you're researching, they send you the data. So I sent him there.
Okay, great. Thanks so much. If I could speak to the complainant for a quick second.
I'd like to make a comment before you ask or after.
Go ahead, but make it brief.
Okay. By the way, the note that came from the California Department of Public Health saying you can't have this information was referring to my second complaint, in which I asked for cause of death, underlying cause of death, age, gender, sex, and there were 8 fields, records inside the data. Inside the records. My first request was for how many freaking records are there? I'm not even asking the contents of them, so it's not within the indices, so it's not covered by that section.
Okay.
They haven't answered that, but
sure. Let's roll through these questions real fast. So it sounds to me like the records that you're requesting are only accessible through the San Francisco Department of Health by accessing a state database.
Yes and no.
Okay.
If you go across the street and request a death certificate, the Department of Public Health just pulls up the data from the It's the electronic death record system, and then just print it out. That is accessible to the Department of Public Health, and since they are the ones who certified it, they should have right to find out how many. There should be a log somewhere.
I understand the point you're making,
right.
But the previous testimony suggests that the tool that she uses to obtain that information is a database maintained by the state of California, and she's testifying that the state of California is telling her she can't give that information. So let me just walk through a couple of these pieces here, and then I'm sure someone else will have questions, and you'll have a chance for a rebuttal at the end. Have you looked into what data you could potentially get from the county coroner's office?
I haven't gone. I got stonewalled by them, so I got sent around. First, I went to the coroner, and they said, "No, go to Department of Public Health." Department of Public Health sent me to the clerk's office, county clerk's office, and they store death records from 3 years and back. So actually, the first half of my data is sitting in the county clerk's office. They have it. But I wanted that complete period, so I went through the Department of Public Health.
Okay, well, I would encourage you to follow this sort of same process you've taken to the one agency to any other agencies that might have any or all of the data.
Police even,
In the process, you may or may not get a complete record of data, but if you have enough incomplete records, you maybe can piece them together.
Mm-hmm.
From what I'm hearing, if I read everything just on a superficial basis, the Department of Public Health is saying they don't possess these records. They're owned by the state of California, and they have access to that database. And the state of California is telling them, no, you can't give it to this gentleman. He needs to go through us. Do you doubt that testimony, or is there some other reason that you think there should be a violation found for?
If you read the section of the public health, it talks about the indices, which are complete databases. Obviously, they're not going to give those out. And then they talk about comprehensive death records. I'm not asking that neither of these apply to my request. And in any case, that was referring to my more detailed request when I asked for 8 fields off the death certificate, and not for the existence of the records themselves. The California Department of Public Health have not answered that question, and Department of Public Health are quietly sort of forgetting that's even a thing. I'm still waiting. I've been waiting since August 22nd. I've been told why. These deaths are somehow a state secret. They should have a record of how many times they logged in, at least.
No, I fully understand the argument.
And I've been stonewalled, sorry.
I'm just trying to sort of walk through what the potential legal violation was. So, if you ask for my Hulu password and I call Who up and ask whether I can give my Hulu password to a random person, they say no, there's not much we can do about it. And it sounds like the state of California is tying our Department of Public Health's hands in providing you that information. Now, are you arguing that that's an unlawful tying of the hands by the state of California? I'm just trying to figure out what sort of path there is for any potential violation.
First of all, I'd like to I just want to guess, I at least want to know how many people died. That has not been addressed by the Department of Public Health in California. They haven't said, is the existence of a record exempt? They haven't answered that. I need to know that at least. And beyond that, what in this record is secret? Because, for $22 I can go across the street and get a death certificate. That's not secret. I mean, when I first tried doing this in May, I said, yeah, sure, you can do it. If you pay $22 for every single death record, yeah, you can have it. So it's not secret. They're hiding this stuff for some reason, and I think it's this. There seems to be an awful lot of pushback on something which is a very simple call. I mean, the first time I came and I was asking for how many people died per day, I said, oh, we can't do that. It would be too hard. We'd have to run the report 800 times. Well,
I'm sorry, who said that to you? The state or the city?
No, Linda told me. The first committee meeting I was here. This is my fourth. There were 3 committee meetings I came to beforehand. When I requested this, she said, "Can't do it because it's too hard. It would take us too long to do. We'd have to run a report for each single day." And that would take so long. They could have sent a file clerk if it was, through a Indiana Jones warehouse and gotten the same information. So that was the original argument, which was, sort of frowned upon by the committee members. This is why can't I find out how many people died? And by the way, the reason. I'm not pursuing the state aggressively is because the restrictions that they lay on this. For example, if I find that on heavy spray days there's, an extra 40 people die of respiratory failure, that is data from the database. And at the end of my research, I must destroy my data. And I have nothing to back it up unless someone else has to jump through every single hoop that I have. It is not the restrictions on there. There's cost, and they are keeping this very, very, very tight, just like the CDC.
But the point is if there is existing law that allows that to happen, whether or not it's nefarious, the law is the law, and that's what's going to be followed. So that would demand a change in the law for your needs to be met.
Well, the death record should be.
It should, or whether
it should, but
the law allows for it is two different things.
The Sunshine Ordinance says anytime there's a conflict between local laws, we're in California. California is local,
But the point here is if the DPH is claiming and citing state law, and that this information is not public records owned or controlled by San Francisco, but by the state, specifically what you're asking for, then it's not a local law. It's a state law.
The Department of Public Health has access to this data, which came through here. They can say, yes, so-and-so died here. Because, for example, if I took a picture of everybody here, Dave, Bruce, all that, and that photograph is copyrighted, it has your names on it, does that stop you being able to use your own name? No. Just because they have a proprietary product which includes these things and it doesn't make it theirs. And we can demand, since the city themselves logged in so many times, and to even get the terminal logs, those things, nothing, completely shut down. I don't even know if anybody died. And we have, again, I'm going back to, Department of Public Health, what are they there for? But I'd like to go back. The law that was quoted referred to...
I want you to hold on a minute, because we have somebody else who wants to ask a question.
Sorry, I would like to ask Ms. Acosta some questions.
You would? Okay, so hold on a second. Mr. Roddy, why don't you finish your thought?
Yeah,
and then we'll
again the law quoted by not a lawyer from the California Department of Public Health referred to the second request where I was asking for contents of records. My first request was not for contents of records; it was just the existence of records. That's something quite different, and certainly not comprehensive.
Very good, thank you, Member Moss.
Hi. So I have three questions, and the first two are just related to definitions. I was wondering if you could just define what indices are in the context of the law you cited at us.
Is that something I'm required to do?
No, I just want to make sure I understand, because you're citing this thing about how not releasing indices, and I just want to make sure I understand what an indices is.
Okay. Well, hold on.
You don't have to. I guess it's not a legal requirement, but I can't, understand.
I assume it's records.
Okay, so.
But let me look back at the note. I would interpret that as records.
Okay, so we're not sure at this point what an indices is. It is a record, but the record could be anything.
Collections of records.
Okay, and then what is a registrar? in terms of what the Department of Public Health does?
So as a local registrar, again, we go into the California database and check a number of boxes saying that, everyone has done their part. So the coroner has submitted their report, the physician has signed off on it, the record is complete, and it goes to the state.
Okay. So as we were having a discussion, I was going through the file here, I felt like I had this feeling that I'd seen some of this data that he was asking for already on the public health website. And so what I was looking at was the 2016 San Francisco Community Health Needs Assessment, which includes an entire section called Mortality in San Francisco. And the first sentence of that section is, there were 22,450 deaths in San Francisco between 2010 and 2013. And what I'm wondering, and I mean, it has it broken up by like race, it has it broken up by like what the disease was, it has all sorts of information and data here. And I'm wondering what the difference is between the data in this report and the data that the complainant was seeking.
You would have to ask the epidemiologists that prepared that report how they got their data. I'm not aware of how they would get that data. I don't work with them, so I don't know.
Okay, thank you. That's all.
That's it? Yeah,
Go ahead.
I have a question.
Okay.
So the first request for the number of people who died by day, this information is on the state website?
I don't know what's in the state database. I don't think that there's a report by day of how many people die in the city. What there is a collection of death records.
Okay.
So
and there's no digital tool, report writing tool that somebody can go. So so
there may be, but it's the state that controls it.
Okay. So the city, San Francisco Department of Public Health, can't even give Mr. Roddy a number.
Correct.
Even if it took you half an hour to produce it, the state doesn't allow you to disseminate that. Okay. Thank you.
Don't leave yet. I have some questions. So under State Health and Safety Code 102230A2, that's the one that you're referring to? It says the birth, death, and marriage record indices prepared pursuant to paragraph 1 and all comprehensive birth, death, and marriage record indices prepared or maintained by local registrars and county recorders shall be kept confidential and shall be exempt from disclosure under the California Public Records Act, in that section. Okay? It doesn't say anything about ownership or anything in there. And the prior reference to in paragraph 1 just says the state registrar shall arrange and permanently preserve the certificates in a systematic manner and shall prepare and maintain comprehensive and continuous indices of all certificates registered. So what I'm reading here is that local registrars and county recorders prepare and maintain records.
Again, from what I understand, we go in and we check boxes to say that everything is complete.
Okay, so you're saying that is the job of the Department of Public Health? Are you saying your job is not to prepare and maintain these records?
Correct.
Who is?
The state.
No, locally, the local records.
Again, the coroner gives some portion of it, the physician gives some portion of it, the funeral director may give some portion of it, and then together that report is in the database. One of our clerks opens that database up, looks at the report, says everything is there, send it to the state.
Okay, so that in and of itself is a record?
Yes.
Okay. So are you able to provide how many of those records you have sent to the state?
No.
Why not?
Because that is not a record. We don't have records of it that would that would entail going in and looking at each day and saying how many records are there on this day, day 1, January 1, etc., through the entire year.
Does the state require an audit to reconcile how many they received and how many you have sent?
I don't know.
Okay. Because from what I'm hearing from Mr. Roddy, the one thing that I'm concerned about, beyond all the other information that he's asking for, is you're claiming there's a dearth of information, okay, or that there's no information.
I'm not allowed to give that information out. Can our clerks see it? Sure.
Who has the authority to give that information
The
out?
state. And they give it out. They have an application for it. It says researchers apply right here.
Who's the gatekeeper in the Department of Public Health that would ultimately make that decision?
The California Department of Public Health?
No, the San Francisco Department of Public Health.
The gatekeeper who would make that decision.
Yeah, the person that would say, nope, I'm definitely not going to allow this information to be released.
Well, I can give you the name of the director of the department, but it was really the state ultimately that told me, because what happened when we first were here, the first 3 times, I was going back and forth with the clerk.
I see.
With the same argument you had.
Got it.
What if? How long would it take you to do this? Let's figure it out. Let's do a report together. I was really trying to get Mr. Roddy's information. And then as I pushed on and got a lot of, just sort of, no, we don't do that. No, we don't prepare that report. I finally got in touch with the California Department of Public Health, who said, you can't give that out.
Okay.
And that's what they, I think, meant to say, but they didn't know that was the case.
And was the citation in the Public Health and Safety Code, is that what they gave you?
Yes.
Okay. All right. Thank you. Member Muss.
So I'm inclined to make a motion to continue here. The more I look at this document that I brought up my computer, and I don't want to introduce it into this hearing, but I think it merits adding it to the record and considering it next time. Because at the very least, I'm looking at this, and it at least covers a portion of the records that the complainant was seeking. So I am literally looking at the number of deaths for various causes and for various races for a period for all of 2013. And he had asked for specific months beyond it, but nevertheless, it feels like there may be worth the Department of Public Health going back and looking at what it's already released online and figuring out whether some of that record is responsive, whether some of the underlying records of that have already been cleared to be made public. Just because, I don't want to introduce this. I think that we can consider it the next time.
I would just note for the record, in this particular section of state code, it was amended in 2016.
It was amended in 2016.
It was amended in 2016. It was effective September 9th, 2016, so it was an immediate...
This was released in 2017, this document.
Oh, okay.
Yeah.
Okay. So I just wanted to say that, I don't know what was amended in here, so that's all. Okay.
Can I respond to that?
Sure.
So if an epidemiologist requests that data, yes, they can publish it, right? And that's where you go, is to the state, get your data, and you're allowed to publish it. It's just that you need to go through the proper channels.
Right. But if he had asked for the records, the data that already appears in a document that you've made public, then he should have been directed to this document. Or at least that, I don't want to get into us arguing that now because we don't have the document on the record, and so I would like to enter it into the record.
So, okay, let's discuss that in a moment.
Okay.
I want to give everybody else an opportunity, and then we could talk about procedure on what we want to go next. You suggested possibly continuing this. So we'll go with Member Kanata and then Member Wolf.
I'm fine.
Okay, Member Wolf.
I like the idea of continuing this, but what I'm hearing is basically that gatekeeper preventing the employee of the city of San Francisco from giving that information is actually a state agency. And I don't know whether we can send a request for information to the state public health, but I would like to understand better how this came to be, what the reason for this denial is. I realize it goes beyond the scope of our mandate as a Sunshine Task Force, but at the end of the day, there is this record that the only reason our local government doesn't doesn't keep their own accounting is because the state has built up its own network and then denied our city from giving access to that. So I think it's important to better understand that and potentially to recommend that this county maintain their own records. I mean, obviously they're probably not going to, but basically what's happened is that rather than maintaining local records, we've created a state record that then the state is controlling access to, and that is a little disconcerting to me.
Okay. Member Moss, can you state the reason for continuing?
I would like to to continue this matter that.
Should we go through rebuttals first?
No, I don't think we should go through rebuttals. I think
good.
we should save that and not waste people's time.
Okay.
So I would move to continue so that the San Francisco Community Health Assessment and the San Francisco Community Health Needs Assessment appendices can be added to the record and reviewed by both the complainant and the respondent to see whether there are responsive records around this, or so we can discuss it at the next hearing.
Okay. Is there a second?
I'll second that.
Moved by Member Moss, second by Member Wolf. Any discussion on the motion, members? Any public? Go ahead, Member, testify.
I just think that, the parties should use this information that they've heard today to pursue this line of action, and I don't think it merits us continuing the item based on information that we are finding on our own, off the cuff.
Are you seeking to make another motion?
No, I'm just going to say I'm going to vote against the motion.
Okay. Let's call for public comment. Any public comment?
I don't think we provided an opportunity for rebuttals yet.
Where Member Moss had suggested that it wouldn't be productive to do rebuttals until this information was seen, so that way if there's some alternate adjustment to the case, that could be made, and then once that information, now it's being introduced by the task force to the parties, that will continue it and then continue where we are now is discussion, and then once we're finished with all of that, based upon responses from the parties, then we'll have rebuttals. Okay. The public comment on the motion. No, your party, sir, we don't, because you've already had your. I do have a comment I'd like to make. Okay. Yeah, I'm sorry?
I do have a comment I'd like to make if possible.
I'll take it here at this particular moment, but not as part of public comment. Your party, so you can. Well, I'm allowing you to speak.
So really, what I want is we haven't had even a legal opinion from the state whether the numbers of deaths were somehow exempt. They weren't asked that. This section was quoted for the second part, and that and I think the city attorney should check into this law.
I'm not following you. So
my original complaint, the most important one, is how many people died.
Right.
The response from the state of California was responding to the second request when I asked for cause of death, age, gender, a significant records with, fields within the record. Right. The original one was just how many records themselves, which is a separate thing, and we don't have a opinion either from the state or from the city attorney on that.
Right. So
that needs to be looked at.
I think, and the members can chime in, but I think I can speak for the members here. Mm-hmm. The respondent claimed that it was they were unresponsive. There are no responsive records.
That was the response to the second request, not the first request.
How many deaths?
They won't even say how many or if anyone died.
Unresponsive.
unresponsive. They did not reply. That was the original complaint. When they said they were going to try and get it to me in 11 days, I dropped that first thing because I thought they were going to do it, and then they stonewalled me. And then they quote when I asked for the more detailed one. That's when they got the thing from the state.
And I completely
so it doesn't apply to the original one.
I completely understand your concern about that.
Right.
First they say yes, and then they say no. Or we don't have it.
But the state hasn't even given an opinion on the original complaint.
I understand that, but
so that needs to be looked.
We have no jurisdiction over what the state does or does not do.
Well, the city attorney should have some idea whether...
But that's not our jurisdiction. That's somebody else's jurisdiction.
Well...
Our jurisdiction is specifically to California Public Records Act, the Brown Act, and the Local Sunshine Ordinance. That's it.
And they violated that because they didn't produce the numbers of deaths. And the only defense that they have, this quoting the comprehensive death records cannot be given, was only referring to my second request, which was more detailed. The original one, the numbers of death, has not been addressed.
But the numbers, the question is are there records? If the department, we can't determine whether there are records or not.
Well, there are records. This was testified at this hearing where the clerks can look up records through the system. So they can tell. They can even look at a date and say, oh, look, there's 4 deaths there, and write it down on a piece of paper.
I don't know if that's the way that system works.
It's a database.
Some databases, there are a lot of databases that don't collect logs. There's lots of stuff like that. If it's not described to us in any specific kind of way,
we were told.
I think, Mr. Roddy, in the interest of time, because we are going to continue, we most likely will continue this item, is with the introduction of the information that Member Moss is now including in this record. You should review this. Ms. Acosta should review it. That has specific information. I think that's
unfortunately not by day. That's what I'm actually the core of my research is how many people die per day. Over a period won't help me. Unfortunately,
I understand that, but we can only do so much. We have very little authority to compel anything. Okay, if we find that a record exists, and we know, and there's evidence that it actually exists, and an agency or a department refuses to produce it, then we have authority to compel them to produce it, because if we find that it's a public record. And in fact, the city attorney's office has their own supervisor of records that does more or less the same job as what we do. Okay, and that's contained in the Sunshine Ordinance. Okay, that if they find that a record exists and that it's public, and the department or a custodian refuses to produce it, they themselves can report that person to the state attorney general. Okay. We don't have that kind of authority per se. We have authority to refer it. Okay, but we don't have the same weight as the supervisor of records, who is the city attorney, to be able to do that. So what we're doing, because you presented this to us in this venue, is with the extension of Member Moss introducing this new information, we're going to continue the case. Both you and Department of Health can review it, see if it pertains to anything. Maybe it spreads some light on something, and that is information that's publicly available because it was produced in a different set of channels, kind of thing. But in the essence of time, we feel that we would spend an enormous amount of time continuing to go down a rabbit hole for this right now.
I'd like to sum up one thing. Someone should ask the California Department of Public Health if the numbers of deaths per day are exempt. That has not been asked.
I understand that. Again, it's not our jurisdiction. Yeah. We are procedural.
I know.
Okay, so when it comes to the content of those things, it's one thing. If it was some specific procedure, like the state is supposed to deliver this information to the local agency to preserve for local consumption, that's one thing. But we have not heard that.
Yeah.
I think what Member Moss is introducing is that there's some evidence that exists out there that is kind of counter to what's been presented here today, and that you folks should look at that. And that we'll come back sometime in the near future, and we'll review this again with that new evidence. Okay?
Good.
Great. Thank you. Okay. So we've reached a point to now where we have a motion on the floor?
Yes, there's a motion to continue.
Yeah. Okay. Now public. Okay. Any public comment on the motion? Seeing no public comment, please call roll.
On the motion to continue the matter to the call of the chair, Member Moss.
Aye.
Moss, aye. Member Josh Wolf.
Aye.
Wolf, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensey.
Pass.
We're all this way.
Highland, absent. Member Eldon. Eldon excused. Copra, absent. Member Tesfa.
No.
Tesfa, no. Member Kanata.
Aye.
Kanata, aye. Member Hensey.
Aye.
Hensey, aye. Chair Wolf.
Aye.
Wolf, aye. The matter is continued to the call of the chair. I would like to request if Member Moss can send me that link so that it can be included when we do reschedule.
I don't want to be that kind of.
And I do encourage the parties to, I will send a copy of that link to the two parties when I do receive it.
Okay.
I was just.
Next on the agenda, item number 8, file number
Wait,
17122.
we're not taking a break?
Oh, how many more items do we have?
This is our last complaint.
Okay. Shall we forge ahead? It's the last complaint.
Okay.
You need to excuse yourself. Excuse yourself. I do. I mean.
Yeah.
Item number 8, file number 17122, complaint filed by the La Plaza Neighborhood Association against Supervisor Katie Tang for allegedly violating Administrative Code Section 67.21 by failing to respond to a public records request in a complete manner. This matter was heard by the Complaint Committee on January 23rd, 2018. I believe at that meeting, the complainant stated that the respondent has not provided all responsive records and provided evidence of emails that were not disclosed. The respondent was not present at the meeting. However, they did submit a response letter that is included in your packet.
Okay. Yes, Member Moss.
Before we begin, I just had a question. Did we ever finish the rule of reason document for our rules, or is that still
I don't.
Still pending issue.
recall,
still pending
yeah.
issue? That answers my question. Thank you.
Okay. Are both parties here? Is there a representative from Supervisor Tang's office here? Okay. Please state your name for the record.
My name is Mike Murphy, and I represent the La Playa Park Neighborhood Association.
And before you begin, Mike, in full disclosure, I sort of vaguely know Mike Murphy socially. I don't think it's going to. Apparently, I'm not the only one. I don't think it's going to in any way affect my judgment, but I wanted to put that out there.
Yeah, there's a lot of Mike Murphys around, too, so chances are you probably know Mike Murphy at some point in your life.
That's not the point. The question is he's identified you.
I know.
And we're not on TV, so I'm stating that for the record.
Sure, well,
Yes.
yeah, I got to do the same thing. I met Mike and his wife, 2004, 2005, but it's not going to impact my ability to judge this case fairly. Plus, I haven't seen you in like 5 years. So, hey,
it's been a
hi,
long
Mike.
time.
How's it
Hello.
going?
Okay. Start the clock. 5 minutes.
Okay, the complaint's pretty straightforward. You'll see in your packet the complaint is on page 234. We've indicated that Supervisor Tang's office failed to respond in a complete fashion to a records request. Originally, the records request was made by Tim Murphy, no relation to me, but another Murphy. It was a broad request. And what I did was I restated the request in an appropriate fashion, sent it to Supervisor Tang's office, and also sent a duplicate request to the planning department. The request came back from Supervisor Tang's office and the Planning Department. The index from the Planning Department you'll see on page 236 indicates an email or some sort of communication that was sent from an unlogged device. And that appears to be from Supervisor Tang herself, and was not included in the responsive documents from her office. So the significance of that request is that it seems to us possible that there are other documents that she may have responsive to our request from this unlogged device, and we do not have them. In the interest of time, I'll. One other thing too. Interesting, we come full circle here today. You started out talking about social media and Twitter. Supervisor Tang also posts liberally on Facebook and did not provide those Facebook posts in response to our request for communications. The concern in these sorts of social media posts, which are made in a professional context, is that they may effectively disallow records from surviving transition of officials. And I'd just like to thank you all for your service here on the task force. I really appreciate the work that you do here, and I find it significant, and I'm happy to be here I'm happy that you can hear this complaint. Thank you.
Thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the petitioner, the complainant? Seeing none. Respondent? Is there a respondent from Supervisor Tang's office in the room? There is no respondent. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none. Members? Member Joshua Wolf.
I have a question for Mr. Murphy. I've tried to dig through this record, and sometimes I miss a few things. So I see that you've identified at least one document that you were not provided that, in your estimation, is responsive to your request. Correct?
That's correct. Yes.
And it looks like the initial response was that there were 0 records responsive to a rather broad request that you submitted, right?
That was submitted by another member of the executive board.
I apologize. By your colleagues.
Yeah.
So at this point in time, is there a follow-up that says that there's more records, or at this point they have turned over 0 records? That's just what I'm trying to understand.
The records request, the Supervisor Tang's office did provide a voluminous number of records responsive to the request, approximately 315 or so pages. However, consideration is that there's an unlogged device. There may be more records, and we're not getting them. And there's evidence that this device is unlogged.
Okay, so there's this email that's from July 10th that says, "Dear Mr. Murphy, our office does not have any records responsive to this request."
Right.
So future follow-up resulted in some records. You just don't know whether you have all of them.
That's correct, yes.
Great. All right, thanks. That's what I was looking for.
Mr. Murphy, before you leave, on that page 236, how did you come to get this document?
Page 236, the index from planning. I filed duplicate requests for public records with Supervisor Tang's office and the planning department.
And this document came from planning?
That document came from planning. It's indexed in an Adobe index file, which I have. I took all of the. I have to commend planning for being responsive in an organized fashion.
And what makes you think that Supervisor Tang has that same document?
It's got her name all over it. It says it's from her.
Where?
It's if you go to the next page.
At the bottom of my page, it just starts out.
Page 237.
Oh, on 237. Yeah,
237 is the document.
To Tess Kavanaugh from Sean Kennedy,
No, it's CC Sean Kennedy.
Oh, from below that.
Right.
Okay,
If you look at the index, it says no value. That's because the device is unlogged, wherever it was sent from.
Where does it say no value? Oh, up on top.
On page
you're talking about
236.
that one entry.
Yeah, yeah. What I've done is I've blown it up so that you can see it.
I see.
All right. You see it on 236. It says hi Tess. On 237, it says hi Tess.
Okay. Oh, okay. So what you printed underneath that listing is the actual.
That's the
message.
actual document that
The
came
actual
through with no value. That's why it says to, and there's no from value, because nobody would know who it was from.
Oh, I see.
If you read the document itself, it says, hi, all, blah, 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 Katie. So,
it says there's no from header in there.
Right.
Okay.
There's no from header because it's under the.
Have you. Okay, so here's an interesting thing metadata. Okay? We've been through this before many times, especially when documents were originally scanned in as images, and then made PDFs, back in the early 2000s. And then we found, there's all kinds of metadata that's under there that's maybe part of a draft or something like that people wanted to see, or there would be other information. That's all public information, even if it's hidden from view. So for emails, similar, metadata can be revealed, which reveals not only just all those headers that you see normally, but a ton of the actual path of transmission, okay, and what server it came from and that kind of stuff. Have you requested any? Did they provide you with any of that information?
I have not requested that information from the planning department, no.
Okay. Member testify.
I just have some follow-up questions from Chair Wolf's line of questioning. So where it says no value and it has like a date and a timestamp, so are you saying that the sender where it says no value was Katie Tang?
Yeah, I would just based upon the content of it, and since she's not here to respond on her behalf, it says hi Tess, and then again it's from right below it refers to a previous correspondence that she had sent from her Board of Supervisors address.
Okay.
And then she signed off on it.
Okay. I just have a question about the timestamp. So when it says 10:52 a.m., but then her email is dated 5:52 p.m., why would you think that's the same email? Or I'm not trying to accuse you of manipulating the document. I just don't understand why it says 10:52 on the line where it says no value, and then when you look at the actual email, it's listed as 5:52.
And there's no timestamp on the actual message from Katie Tang.
Yeah, I do not.
Oh, wait a second. There is. I'm sorry.
There
my
is, but it's
mistake.
not the same.
Right. That's
So-
October 12th.
But
I don't
strangely,
have
the
any
seconds
detail
line
on
up.
that.
The seconds line
I
up.
agree. Yeah, that's why
The minutes and the
I
seconds.
said I'm not accusing of manipulation. I just don't understand why some things are matching and some other things aren't matching.
I can't answer that question.
So let me ask you this: what you printed out here, this listing, that was something that you created from another document?
Yes, this printout is from the documents that the planning department provided me.
And what format did that come in?
It came in a PDF format.
Came in a PDF format,
Yeah.
and did it look just like this?
It looked just like that. Yeah.
Like character for character?
Character for character.
Okay.
Yeah.
All right. So you basically just printed out what they sent you.
Right.
You
yeah.
didn't. Okay.
I didn't
'cause I
manipulate.
thought you said that you
make any
had
changes to it. No.
Okay.
No.
Just wanted to make sure. So that's okay.
No, I'm happy to provide the extensive files on that I received as a response from both Supervisor Tang's office and the planning department. But
yeah, I agree. It's a little
It's
odd
voluminous.
that the listing is in the morning and the actual message is later in the afternoon.
I agree.
How's that possible?
I don't know.
Back to the Future.
Could it have been sent from a different time zone if someone was on vacation and
Now you're
using-
sounding like Twin Peaks.
No. That's actually what
Okay.
happens. If someone was in a time zone where 10:52 a.m. matches up to 5:52 p.m., that's exactly what it would produce.
Huh?
Okay, so if you send me an email and I'm in, say,
Oh, a different time zone.
in Greenwich, England,
I gotcha.
and I reply back, the time
Well,
zones will match the minutes and the
right.
seconds, but not the
Right.
hour.
So this is what I was kind of talking about with the metadata. The question is, is that 8 hours? Let's see.
10 to 5.
10 to 5, 11, 12,
Yeah,
1,
8
2,
hours.
3, 4, 5. Yeah, so I bet you that's the server that's set at UTC.
Oh, that's the other
That's
potential explanation.
I bet you that's because this is back in May. So that's daylight savings time would be minus 7 hours
There you have it.
UTC. So it's correct. I bet you that's what the situation is. Yes, the server.
Yeah.
So the server, however they log this, it's
set
based
to
on the
UTC.
server time and not on the time zone time.
So that makes more sense than staff working on their international vacations.
I'm glad we figured that out. Shame on you. No, my servers end up that way sometimes too.
Thank you. I just,
Yeah.
my concern would be if their office did come and say, you just assumed that this was sent from her and there are things that don't match up, so I'm glad that we flushed that out.
Okay, great. Anything else on this? All right. Thank you, Mr. Murphy. All right, members, any other information we need? I guess we'll move to rebuttals. The respondent, again, there's no respondent present in the room. Mr. Murphy, if you'd like to make a rebuttal or a closing statement, you have 3 minutes.
In the interest of time, I'll let you move forward with this. Thank you very much again for hearing the complaint.
Thank you. How should we dispense with this, members? Member Josh Wolf.
I mean, I think from the surface. So, did I hear correctly that they provided some message, but they did not send a representative from Supervisor Tang's office at the committee hearing? Is that correct?
Correct.
So, I think that at minimum we need to find a violation for failing to provide an adequate representative, particularly when it comes to an elected official who, there's an allegation against them, and for them to sort of simply ignore the provisions of the Sunshine Ordinance and just act like they can just ignore it and let it go away, I don't think is a helpful place to be. In this particular case, I understand the arguments that have been put forward that insinuate that there's additional documents, but without being able to have a conversation with Supervisor Tang's office to actually work through that, it becomes a very difficult thing to maneuver, and we end up comparing, timestamps on email printouts and these sorts of things to try to make sense of it. And I don't think that's fair to the process or the respondent. And so I don't know about a larger violation, but I definitely see a violation for failing to provide adequate representation.
Yeah, I agree. I agree with that. I mean, I'm totally. It seems like anytime there is a complaint against the supervisor, I don't remember being here for one where the supervisor actually had somebody come. I agree, but to me, most of the time, I don't see them send somebody. So
The chair, they used to send somebody all the time. They sent some poor beleaguered ledge aide or intern or somebody that, showed up and did their thing and made their case. And is this a new thing?
Yeah,
They used to send that nice young ledge aide. Yeah.
Yeah,
I mean, we always got the lowest aide on the totem pole,
Until
and
recently,
I don't know how recent, but I just my memory is that very rarely.
Is it because
do they send some
multiple hydra-headed screwballs or whatever we were called?
So I agree with.
So is there a motion?
Josh Wolf.
Is there a motion?
Well, I was curious if anyone saw a larger violation than the one that I have potentially identified.
Which one did you identify?
Not bringing anyone to our meeting so that we can actually figure out if there's a violation?
That one.
Yeah.
The one that that would be 21E. For those of you keeping score at home. On TV.
So I'm prepared to make a motion, but if
Yeah,
someone
let's
wants
go
to
with that
argue for an additional violation, I'm leaving that space, which isn't being jumped upon.
All right, so we have one potential violation, not sending somebody, a representative. Are there any other points?
I mean, it did look to me from the social media that there were responsive records there that weren't provided. But again, like Member Wolf said, it's hard for us to conclude anything definitively without a representative here, and I'm not sure where we err in that. In that, so I mean, but at the same time, I mean, did I mishear the complainant in saying that he was provided with like 300 pages of stuff that is not in our packet?
Yeah, and this particular one was not, and because it had Katie Tang's name on it, and it looked like they were forwarded. It didn't have any from header on it. It raised this concern that there may be more records than this. And
I think that's a fair concern. I just wish we had the whole response in our packet here, so we could just verify that the document that he says should have been included is not included. Because at this point, we're just taking his word that it wasn't included because we don't have the full set.
Member testify.
Am I confused?
I thought there was a response from Tang's office saying they do not have any responsive records. So,
right. So maybe I misheard because I thought he said right after that they went back and forth.
So you can ask him. Mr. Murphy?
I'm sorry if I'm confused.
That's all right. We're ferreted out. Let's get it correct.
Yeah, the original response from Supervisor Tang's office was that she had no records responsive to the request. However, when she was pushed, and when I filed the request, she came up with the records. However, again, we're concerned that there are additional records because we've already found one discrepancy. There may be any number of others.
So just to make sure I understand, so there was a request filed and there were two requests filed. And this complaint is about both requests that were filed?
Yeah, this is from the La Playa Park Neighbors Association, of which I'm a member.
And so what was the other one then?
The original request was filed by Tim Murphy. It was overly broad. They simply said they had no records, which was, I guess, they're in theory what they were. The reason why they said they had no records was because they thought he meant or. They assume there's a Boolean operative between the different items that he requests the response from, rather than and. 'Cause I mean, in actuality, he did request for all documents containing the words "planning department," which would have been a bit broad.
Member Josh Wolf.
So our packet does not contain the most recent cache of documents you have received from Supervisor Tang. Is that because you didn't send it to Victor or because Victor didn't include it in our packet?
I did send it to the secretary. However, I sent it as a Dropbox file because it's so voluminous. It's 300 pages, and I didn't assume that anyone would actually want to read it. And he said that that's simply not something that you use ordinarily. It's easy for me to forward it. I've made it open so that anyone can look at it.
Sure. I mean, it sounds like Victor has access to it. In order to identify, like Member Moss was saying, to verify that there's even this small violation of this document that you claim wasn't included.
Right.
I don't see how we can make that determination without the original source material. So I'm inclined to make a motion to find a violation for failure to provide a representative and continue this pending getting that information and reviewing potential other violations. I don't know whether anyone else is interested in that course of action.
Well, if you're going to make the motion, let's see if we can
I'll
get a second.
go ahead and make someone remind me what the section I'm looking at, number 6721, is that right?
21E, yeah.
21E. I'll make a motion for 6721E as well as continue the item pending Mr. Murphy's provision of the existing documents to identify any potential future violations at the call of the chair.
So let's say instead of pending, requesting that information.
Sure,
Mr. Murphy.
Requesting that information.
Okay, great. And we'll make sure that Victor has whatever information, way to get in touch with that. Okay. Is there a second?
I'll second.
Moved by member Josh Wolf, second by member Moss. Any discussion, members? Seeing no discussion, any public comment on the motion? Seeing no public comment, are we ready for a vote? Please call the roll.
On that motion, member Josh Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Hinsey.
Aye.
Hinsey, aye. Highland, excuse. Eldon, excuse. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay.
It is my understanding they were asking that the complainant provide the additional documents, but I'm just going off the top of my head in that I would hope that it would be organized and explained or something to that effect, because from my understanding there are several hundred pages, and I just want to be sure we have a reference to exactly what we're looking at.
Okay, so let me ask, Member Josh Wolf, since you're the maker of this motion, how are you expecting to receive this? Just as tons of documents? Did you want them categorized?
Well, I mean, presumably they were provided from Katie Tang's office to Mr. Murphy in a certain way, and I don't think it's fair to ask Mr. Murphy to further categorize what's been provided. So in essence, providing that core document in whatever form Supervisor Tang gave it, and the real purpose is that if this document does exist in the records that were provided to Mr. Murphy, then there is no evidence of further violation. If this record doesn't exist, then not only is there evidence of an additional violation, but there's also a suggestion that there may be existing documents that Mr. Murphy has not yet obtained.
Okay. Fine. So just provide whatever you have in the way you received it. I think it would be best if we received it as an electronic link to that compendium.
It's just this is going to be such an extreme size. I won't be able to post it online,
but you can you upload it to?
I have a size limitation.
Oh wait, there's a Dropbox. There's already a Dropbox link. It sounds like Mr. Murphy is able to keep that Dropbox link active at least until this is rescheduled. Can't Victor just put the actual link to the Dropbox in the file?
Forward you the link from.
The hard part is that you're asking that this become part of the record.
Mm-hmm.
That means it has to be in our possession, not in somebody else's possession, or in some case, Dropbox decides to shut down, connection to that.
Right. Well, and technically, Mr. Murphy is maintaining the tie to that. It's
right.
not.
So we're asking for it to become part of the record, so it's part of like the PDF, that we have.
So there's no protocol for the city for a server for you to post something and
it's an outside vendor, and I'm not authorized to.
No, I understand if we use Dropbox as an outside vendor, but there's no way to put a zip file on the SF.gov server and link to it?
We have a 25 meg limit on what we can upload.
We not just split the file? Split the document and upload it in three parts?
You could. Sure.
How many megs is the file? Do you know, Mike?
It came to me in 9 parts, PDF.
9 part.
Please
PDF.
come up to the mic.
Can you step up to the microphone, please, just so we can get it on the record? Thank you.
Sorry. The file came to me in 9 parts as a PDF. 9 separate PDFs.
Do you know what the size of each PDF is?
I do not, off the top of my head, no.
Okay.
If you can just get it to me electronically, I will take it. I do what I can with it.
Okay.
But I'm just stating that it will be very large, and
So if that's the case, let me know. I'll call DT and I'll.
And it's just a matter of the paper packet also. It'll be in the thousands.
Well, it's true. I mean, this is now going to be part of the public record. It's got to be made available.
I mean, I understand that there's an environmental impact of putting this in the record, but the problem is that the complainant has made an allegation that this needle is not in this haystack, and the only way to prove that allegation is to obtain a copy of the haystack.
Yeah. I remember the days when I used to get 500-page agendas.
But given that Victor is bound by a 25 megabyte limit, that's probably potentially a citywide issue in light of the fact that Mr. Murphy received 9 PDFs. I'm guessing there's a greater than 50% chance that each of those 9 PDFs meets the city size requirement.
So here's the thing. Let's balance this on the best, what's in the best interest of the public. What's in the interest of, however that phrase goes. The question is there any other way to be able to determine whether this exists or not, without us having to go through it?
The Supervisor Tang's office could come in here, and so that is the other thing that is preventing us from doing this a simpler way, is that we don't have somebody that we can ask, was this document in your thing? If they're not here, they're not here.
Well, just because it's entered into our record, is anyone obligated to actually print a copy of this thing, or does it just exist potentially? I mean, I know you have a printed copy, Victor, but is there an obligation to actually print these thousands of pages by putting them into the agenda?
There is not.
Okay.
But I would have to make a determination of what to actually print and put into the paper packet for public review.
Yep.
While everything else would be available online.
I mean, you could do it on a per request basis for printout. You can do it, make it available, electronically.
That's not a problem. I've dealt with it in the past.
Okay, so if we can make it available electronically, and then state wherever we make the postings for this kind of thing on the website or what have you, in a paper agenda or what have you, state it's available here at this link. If you wish a paper copy,
I can deal with it.
Okay,
no problem.
Okay, is that okay?
It's good to me. I think we've got a.
Yes, Member Canada.
I mean, does this bring up a larger issue, though, of how we handle respondents who just don't show up? And should we have a discussion on it? Not at this particular moment, but it seems like, especially with the new way that we can send stuff to ethics, if respondents continually don't show up, they're just ignoring everything.
So can I make a suggestion? Put it on your agenda for discussion, and comb through whatever, state code, local code, with regards to sunshine, and see if there's anything that can compel them. I mean, we have it in our procedures, okay? That may not be enough to compel them to show.
But there's a violation for not sending someone.
Yeah, right.
That should compel them to show.
Right. So, if you want to have a larger, more broad discussion about it, bring something to us from the committee. Have the discussion there. I think it's not appropriate to have a long, drawn-out discussion here.
So, Vic,
Member Hensey.
Just to clarify before we do anything on this, so Victor's going to put the link up to the. Dropbox.
I do not have specifics at this time, but I will make sure the public has access.
Okay. Cool.
Okay.
That's all pending my motion passes, right?
The motion is already passed.
Yes, the motion is passed. This is extraneous discussion.
And that's not a password protected Dropbox or anything.
No, it won't
I will
be
not
Dropbox.
be using Dropboxes.
Oh, okay.
These city servers.
Oh, and I would just probably ask if you could probably bring it to us, email it in small pieces, or bring it to us on a zip drive, and I can make a copy. At your discretion, please call me, and we can work that out.
Great, thank you. Okay, Moving on. Next item.
Next on the agenda, item number 9.
Sorry, Member Wolf. Could we please have a break?
Sure. Let's take a 10-minute break to a quarter. It's 7:35. We'll be back here at 7:45.
Well, yeah, I had requested.
Next on the agenda is item number 9, file number 17135, hearing to review Administrative Code Section 67.21 regarding the legality of a named respondent in a public works request who is in custody of records, transferring the responsibility of fulfilling the request to another member of the staff without notifying the requester. This was heard at our last meeting, and there was several opinions and differences of opinions regarding this matter. I have provided a copy of those meeting notes to all the members.
Okay.
I sent it to you via email along with the agenda packet. It is an attachment to the notice of the agenda being online.
Is it the same? Wait, is it different than the one that you've handed
It's the
out?
same one that I give to everybody.
So this,
yes.
This one.
I
it's
didn't
this
get a
then.
copy. Do I need a copy though, or are we almost done here?
I mean, you can
I'll
have it
look
on paper.
with my neighbor.
No, but it's just, you don't have one. Is that not what you're looking at right
No,
now?
I grabbed that thing from the table.
Get your own, Louise.
I don't want to interrupt everybody. So what are we supposed to be looking at on this?
Page 6.
Page 6 says. Oh, this bubble right there.
So I just want to say I don't want this to be confused with who shows up on behalf of a custodian as a representative. That's not the issue here. Member Josh Wolf.
This so-called compromise, I don't know whether that was put forward by City Attorney Cola or was reached through consensus. It sounds great and all, but we don't have any way of actually getting departments to follow that as a procedure, so I'm curious how these are supposed to actually fit together.
I would say it's not the responsibility of the departments, but the actual individuals who are part and parcel to the request. That it's their responsibility. It's not so much
The respondent individuals or the complainant individuals?
Part of this, well, there are two issues here. One is when a specific person is requested records. There's another scenario where the department is asked for records. So when the department is asked for records because they don't know who to talk to, it's like, how many gopher traps are there in public parks in the city? And they don't really know who to ask for that, so they send a general request to Rec and Park. Then there's a public information officer there that will process the request and will go around and ask all the pertinent people, create the responsive records, and deliver that to the requester. On the other hand, if the person knows the gopher wrangler and made a request directly to the gopher wrangler, and then the gopher wrangler decided, I don't really have time to do all this kind of work, I'm just going to hand it off to somebody else, and that person's going to respond, not in their name, but in their own name. So now we have a new person that's involved in this. And then the requester gets that information from that second person, and now there's all kinds of information that's not included that it's almost completely unresponsive. The onus should be on the person who has the information, who is the person who was originally requested by name. And to me, it's shirking their responsibility as a custodian not to do the work. Now, if the person who was originally asked for the information knows that they don't have that information, then it's their duty, even under the Sunshine Ordinance, to assist the requester as to where they should find that information. And I'm saying that those responsibilities should be followed. That's how the law is written. Now, we've heard from some other members is that all that is more or less trivial, and as long as the requester gets the information that they asked, that should be enough. And my rebuttal to that is, then why is all this other stuff? Why did the voters approve all these other requirements that are law? So now there were some other arguments that the code in 6721 starts out by saying every person having custody of a record is a custodian, and then in B it says a custodian of public records shall as soon as possible. Doesn't say like the person, the custodian. I think that is semantical.
So if I'm making a public records request to a supervisor's office and I happen to know their staff, and I think that staff person A is the one who has this information, so I send a request asking, supervisor staff member A for this information, and they go, oh, I stopped working on that, and they hand it to supervisor staff member B, who goes, oh, I've got that information, and staff member B writes back, and then I file a complaint because I didn't get a response from staff member A, even though I got the actual responsive records from staff member B. You still see that as a potential violation?
If staff member B provides you with information and it's incomplete, and staff member A actually has the information that you want, staff member A basically is shirked their responsibility to the response.
If staff member A has possession of that.
You wouldn't know that. I mean, essentially, you wouldn't. There could be a situation where you wouldn't even know that because staff member A is now not part of that request anymore. If staff member A were to contact you and respond to you and say, this is the way it's supposed to go. Staff member A says, Mr. Wolf, I do not manage this case anymore or this information anymore. I've handed the whole thing over to staff member B. Please, connect with staff member B for a responsiveness to your records. Okay, fine. That's a level of information, of informing the public of how the chain of where this information is going.
Sure. Because
the public is full of unknowns. And the custodians have all the knowns. So that's the purpose of how this is written, is so that the requester the public isn't left in the lurch of trying to figure out who has what. It's up to the custodians to be able to make sure that the requester gets the information that they have requested. And if they don't have it, they should tell the requester. They are to tell the requester, I don't have these records. I am assisting you by telling you where you can find them. And it's just so you could actually keep a paper trail. So if there is a complaint down the line and you end up here, you could at least show a chronology or at least a paper trail of who you contacted along the way. It helps us also to figure out, well, maybe the original requester does have this information, but now it's 10 people down the line and we've lost track of the chain of custody at that point. So when I'm inferring and suggesting is that 6721 is written in somewhat of a sequence, in steps. Step A, you do this. Step B, this happens. Step C, this happens. I mean, if you read it in that way, it does read that way. You ask for a record, they have this much time to comply. Okay? If they don't have the record, they're supposed to assist you. If they fail to reply, well, then all this other stuff happens. And then if they refuse to produce it, they have it and they refuse to produce it, then this other thing happens. I mean, it is escalating. It escalates. So that's kind of, I think if we just summarily say, well, the public gets the information no matter how they get it, then you lose that whole escalation and the ability to escalate it. And we end up in a trend or a culture for future Sunshine Ordinance task forces to gloss over it and to say, well, that stuff doesn't really matter as long as they get the documents. And then it's up to becomes the burden of the requester to figure out whether they got the documents or not. I mean, we just had a case where a guy went through 300 pieces of information, sees some discrepancy, and it's on one particular piece of record. Okay, and this came from both a planning department and from the person in question. I mean, to me, this speaks specifically to that kind of situation. You want to speak to the supervisor themselves. Okay, if somebody in their office is doing the research and all that on their behalf, when they show up here, it's in the name of that supervisor, not in the name of that aide or that person doing the work for them. That's where I stand on this.
I was just going to mention, because I remember this discussion, and it was because the woman from the SFMTA stated that their department has a procedure that no matter who is named in the request, that gets funneled up to the custodian of record. And then the custodian of record works with the people in the department to compile the data. So in your example with staff member A and B, if staff member A gets a request and hands it off to staff member B, but if staff member B, if I made the request and staff member B responds to me saying, I'm responding to the request you made to staff member A, I wouldn't see that as a problem. So I don't, from your description, I'm not sure how you sit in that scenario.
So I'll make it a little more specific, okay? There's a project going on in a building next door to me, okay? And that project has a city project manager named Project Manager A, okay? Project managers don't share projects in city planning. You know, everybody gets assigned, right? Mm-hmm. So now I have some questions for the project manager, and now I asked the project manager for this information. All of a sudden, I don't get a response from the project manager. I get a response from somebody else that virtually has no connection with this project at all. Okay, and I get some information. Now, I think as the public, I don't know what kind of information is created for this project. I don't, I'm just a layperson. So I think that this is all the information, that what they provided is everything. Now, later, after the project has gone through this whole permitting process, and now they're going to break ground, all of a sudden I find out there's now this big change, okay? And none of that information, and let's say I filed an IDR, no further information was given to me. So I call up the second person, and they said, oh, yeah, no, I don't handle, when there are changes or variances or anything like that. The project manager does for that project. Now what?
Yeah,
But that's but those are scenarios that happen. Okay, we can't. This isn't one size fits all.
To me, that's an obvious issue.
I understand that, but the point is, what we discussed at the last time was more blanketed. As long as the public got some information, any information, then that's good enough.
I don't think that. Yeah, I don't think that was what was said. I think if the public gets information and they're satisfied with the information they received, there is no issue. If the public gets information and isn't satisfied, regardless of where it comes from, then the public puts in a complaint.
Or, they might not be satisfied, but that might be the only information that there
exists.
is.
No, I understand, but okay, so this is not about a complaint. This is about process, okay? This has nothing to do. The complaint comes much later.
Right. Okay.
Okay. So
in your example, if the other person who responded to you said in the response, "I talked to the project manager, and this is the information."
Mm-hmm.
Right, and then
That's
something
different. Is that in your mind? Is that different than you just getting a response from the guy who's not the project manager?
Again, the issue I have with this is I'm asking the person who has the information to provide the information because they are working on that particular
Absolutely,
thing.
but if they provide it through a third party, if they provide it through
how am I to know that?
Because they're telling you.
Yeah, but for instance, again, if there was a variance or some change in the project, and now the third party, I call the third party and says, "Hey, they just dug up part of my backyard. Was this part of the thing?" And now I've got information from the construction company saying that they can do that, and meanwhile the project manager also has that information. That's where the rub comes. Member Tesfaye.
I have a response to that specifically. So the person that was responding to your email is the person who responds to these requests. And that person needs to know that the Sunshine Ordinance requires in an IDR that new information comes on a rolling basis. So if that person says, "Oh, I'm not responsible for the variances," but that person as the custodian of records or whoever, information officer or whomever is handling the requests, is responsible for knowing that with an IDR, you need to be following up with any new information. So in that situation, they might say they're not responsible for managing the variance, but they are responsible for managing any statutory follow-up that is required for whatever type of request it is.
But if that person is not connected to the project at all, they would never know that there was a variance happening.
Well, they would know that this is a request that's occurred through next request or whatever. It was a IDR which requires follow-up, and that's something that they need to flag for follow-up because it's an IDR. All IDRs
So, and
require that.
if that process fails, then I would file a complaint.
Right.
The point is to prevent the complaint, to prevent that
but
problem.
if your variance, so when you requested the public records, did the variance exist?
The variance did not exist.
Well, so so your public records request is responded to. If the variance is created after that, you can't put in a request for future.
An IDR can't. An IDR requires a rolling basis.
Here's the thing: if it caused me harm by not getting the information from the variance when the project manager knew that there was a variance, if the project manager were to have carried the IDR themselves personally as the custodian of records, I would have gotten the variance.
Also, in addition to that, under CEQA, if there's a variance to the project, there's going to be a public notice process, so you would have been notified.
I'm just using the word variance for the purposes of further information.
If you put in an IDR and you say rolling basis, in my mind, that doesn't include stuff that hasn't been created yet. It's for stuff where there's a ton of public records, and I've got to provide them to you as I get them.
That's a different issue, and I disagree with that. That's obviously because the purpose of the rolling basis on an incremental basis is for the purposes of things exactly like this. When you have a project that is starting from zero and moving along a process to like getting permitting, and then there's public hearings for this, that, and the other thing, that's the rolling incremental basis.
I don't know.
That's why that was created. Because there are processes that happen in flow.
I don't read that way.
Well, that's the way the framers thought. That's why they included it. That's why the purpose of the IDR is there. It wasn't meant for, well, we have voluminous and we're going to give it out to you in drips and drabs. That's one scenario. But another scenario is something that is a project that is ongoing.
Through the chair?
Sure.
Seems like we're getting a little off topic. I know. So we've got this agendized item regarding interpretation of custodian of records and who has the obligation of responding, right?
Right.
So what's your end game here? What are we trying to get to?
I think that's clear. We're trying to determine whether the person who is originally asked is the person that must respond, or can it be can they hand it off to somebody else without
Sure, I understand that.
without letting the person know. That's where we're at.
Okay.
Member Josh Wolf.
I at least for myself, and perhaps Mr. Cole was wondering this as well. What are we? Once we've come to that determination of it is this way or that way, what is our end goal? Like we could send out a memo to every department saying this is the way we're operating from henceforward. We can petition to get it in the Good Government Guide or something. But like, what exactly are we? What is our end game once we come to the conclusion?
It would be the position of the Sunshine Ordinance Task Force that this is true.
So we handle everything consistently.
Yes. And we have cases that are pending that involve this situation.
Right, but again, even if we conclude that that it needs to be the exact same person, that you can't defer responsibility without handing it to someone else, in the event that they gave it to someone else, is that just an automatic violation from that point onward?
No, not necessarily. It's the question is when the point is that how do we help guide what the proper process is? If we going to find a violation that the person who receives the request must do either A, B, C, or D, if they don't do any of those, okay, that's going to be a violation. That transmits, as you say, send a memo out to the city family that this is the way the Sunshine Ordinance interprets this particular section and how requests are to be processed by the custodian that received the request. That's an important factor.
Through the chair, I know I stated this last time that we had this discussion, but I differ with your interpretation of the code. I don't think it allows a requester to pick and choose who the custodian of record at each department that actually responds to them is. And I would advise against sending out a letter to departments and city agencies instructing them that that is your interpretation, that is the task force's interpretation. That's all I'm going to say on it.
Well, that's kind of how they get trained when they sit at the War Memorial every year or go through the video for Sunshine Training, that they're responsible. And this comes out of the city attorney's office. We actually they don't ask us for any input on that. And that's the way they train folks, that when people request information from you, you are responsible for doing this. And I'm concerned that we're saying that they're not responsible for doing that. And I want to make sure that if that's going to be the case, that we have some sort of consensus on that, because I don't want to have lengthy discussions in the middle of a case to try and contemplate our navel on it. So I want this. I would like to get this settled. If we have to continue this item again, so people can sleep on it and ask questions or get advice from people, so be it. But this is a very important point, because I read 6721 in a very specific way, and there are lots of people that I connect with in the open government community that also read it the same exact way, including the people that wrote it. So that's where I'm concerned. If people feel that it reads something differently because of the times have changed or something like that, fine, okay. But I want us to get to agreement on that. Joshua,
you've been talking.
Go ahead. Member Test.
I mean, I've been talking. You go ahead. Sorry.
I'm prepared to, if we're going to take a vote on the matter, I'm prepared to do so today. And it sounds like a number of people are. So I would like to make a motion, I guess.
Can you give us a one-sentence description of what we're voting on? Because
Well,
I lost the flick ages ago.
Well, I guess I would just like to state that I am prepared to vote. It sounds like there is still discussion going on, and I don't want to still.
I'm ready to vote.
I see Member Moss's hand is up and Member Wolf, so I just want to say I'm prepared to vote.
Member Moss.
Nick, you ready to vote?
All I want to say is that I am not prepared. I am prepared to vote, but I am not. Have not changed my position since the last time, and I do not intend to change my position moving forward.
Member Josh Wolf.
So let's all just change our position to his position, and then we'll be done.
I think my position is the same as probably Member Tesfai's position, at least because I don't think you've changed your position since the last time.
Let's not speak in cryptic. I mean, what is the position?
My position is I do not agree with Member Wolf. I believe that I am of the same mind, I think, as Member Tesfai and Member Kanata, that a department can have somebody respond to a public records request. It does not have to necessarily be the individual who received it, as long as the individual who received it has handed over the records that are due. And if they do not hand over the records, then they are culpable for the violation. If they handed over the records to somebody else and they never responded, and they had a third party respondent, and the complainant received all of the records that they asked for, I do not feel like giving somebody a violation because of a very, I mean, it's not my reading of it, but it's your reading of it. I don't feel like that we should be violating people for that.
I completely agree, because one thing we never want to do here is violate people. So let's.
Sorry, it's a.
I think we've got 4 so far. Let's keep going.
So I think I was called on to take the floor. So I can see a legitimate argument for both interpretations of the law the way it's written. I think that there's ambiguities in the way it's written that open both interpretations. And I'm not really prepared to vote either way because of that. And my biggest concern is that whatever we decide through some sort of process should be in consensus with the way the city attorney views it, or else this is going to become a increasingly rippling problem. Yeah. So I don't know how to actually reach a consensed vision. I can go either way, but what's critical is that we're all on the same page, both the Sunshine Ordinance, the departments, and the city attorney, and I don't see a path to actually find that consensus.
So I'm here. My concern is not so much what happens here in this room, so to speak. I'm more interested in what happens in the process of somebody trying to get the information, especially when it has an effect on them. That's, if they were trying to get information that's just, of interest, that's different. But if they're trying to get information that has that will have a specific effect on them, and that information is available and is not provided when it could be provided, sure, that could be a violation that comes later, but that doesn't help that person in that moment. It's like if you break ground in a construction project and then you try to take them to court you can't, it's very hard to undo that. You can hold up the project, but it's going to be hard to try to reverse it if they had gotten the information at the jump before ground was being broken, it probably could have been reversed at that point. And it's that kind of issue that comes up a lot of times. And it's not all the time, but I'm saying there is that potential. And if there's any ability for people that come in here to know that they are responsible as the custodian for providing the information that they directly have, I think that sends a very strong message as to what the responsibility of all city workers and officials are responsible for. That's my thrust of this is really how it affects the people, and people shouldn't be trying to go down rabbit holes or wild goose chases to try and find it. If in Member Moss's scenario, if a person requested from employee A handed it off to the department's PIO, if the department PIO doesn't really understand the issue well and collected whatever information they could, meanwhile there's more information that should have been collected in it, and now it's 2 or 3 weeks later and the project has moved on, that becomes a difficult situation. How does how does the requester even know who where that information came from? They don't even know to even ask the PIO, the public information officer, to say, "Can you please ask employee A for more information?" They could say, "I need more information about this particular item," and then the PIO could say, "Well, I really don't know who to ask about that." Now, time keeps going on and on and on, and there are scenarios where there are stalls on purpose or by accident, and things, but the project continues moving. So I'm concerned. Our body is supposed to be representative for the people. It gives the deference for more open government and more expediency and efficiency to getting the public information. That's kind of what I'm sitting on here. Yeah, Member Mouse.
I mean, I appreciate that you have this philosophy and attitude and that you're moving towards the same goal that we all are in terms of transparency. I think when I look at Section 6721 and I apply the way you're reading it across the board, it just becomes madness and results in far less disclosure and far more problems for the requester. For example, if the person you send it to has to respond only to the documents that are in their custody, if I send a request for, I want anything that you've got about, I don't know, whatever. Like let's say, I'm just trying to think of a good subject, like vacuum purchases by the city of San Francisco, and the person who receives it says, I don't have any of those. My only obligation at this point is to tell you I have no responsive records and tell you to email the next person. And that's the only responsibility I have, because this read so narrowly that a custodian is only over their own records. They don't have to do any more than that. When really what should happen is that as soon as you ask for that and they're like, I'm not the right person, I'm going to make sure the right person who can survey everyone gets that record and gives it to you, as opposed to making the requester keep filing sunshine requests until they hit the right person or make sure they get everyone. On top of that, if you're still going to say that, okay, the custodian of records refers to the individual custodian of records, then each individual person has to write the letter demonstrating why things are not doing the legal analysis, or they have to have a city attorney write it for them and they have to sign it. Like, it doesn't make sense to do it that way. And I genuinely feel like if we went down that path, and we can't just write new rules that don't exist in the books to say, well, if your agency says XYZ, then you're okay. That's not in the law. Basically it comes down to, if the person puts in a request and they get their records, done. If they put in the request and they don't get all their records, then they have many options in San Francisco to enforce that. And we have mandatory trainings for every employee about what their obligations are already, and they can get in trouble for not going through that policy. Each department is supposed to have a supervisor of records or a custodian of records and all of these different things. There's a lot of things in place that I don't think we have to go down this route of imagining who has to respond records that is not consistent with how public records are handled by anyone else in the country.
I kind of take a side to it being imaginary. I mean, this is not imaginary. We've had lots of cases where people have not gotten the information because the person who they asked for it had handed it off to somebody else, and they all of a sudden now are absolved from
But they're not. They're not absolved. They're still liable when they come in here.
Then I don't understand why 6721C is in there. Based upon your
6721C?
Yes.
I mean, it just says that they have to assist the requester. That doesn't mean they have to.
In identifying the existence, the form, and the nature of the records. That's not just assisting.
Through the chair?
Yes.
I mean, clearly there's going to be differing opinions on this one. We've had this agendized at 2 different meetings. In the interest of time, I think you guys should just vote on it or decide to continue it again.
Please, don't facilitate my meeting for me. I really would appreciate that. Okay? Really. I mean, we're having this discussion. I think it's really important. I don't think that we should be rushed into anything.
Right. Read the last line of 6721C. A custodian of any public record, when in not possession of the record requested, shall assist a requester in directing a request to the proper office or staff person.
Right.
That means if I receive your request and I don't get it, it's on the
assist the requester.
Right.
Assist the requester.
Assist the requester in having the requester direct the record elsewhere, not the actual person pushing the record on to someone else. It says shall assist the requester in directing a request to the proper office.
Right. And
so I tell you send it to me for the entire department. I say I don't have those records. I tell you have to send it to the entire department. And I'm not going to move your record along. I can tell you where you need to direct it elsewhere.
That's right.
And that's not how it should be within a single department.
But that's the way it's written.
That isn't how it's written. Like this is like I don't read it like that. I read it that is when the agency doesn't have it, they point you to the other agency for you to file another request, not within the agency.
A custodian is, read the first line of A, every person having custody of a public record or public information as defined hereinafter referred to as a custodian of public record. It talks about people.
I mean, if you want to destroy the Sunshine Ordinance, like we can do that, but that's where you're getting at.
Come on. I take aside that you're making that you're thinking that that's what I'm trying to do.
No, I mean I think that's where it goes. Fair. That's where we're going on this. Is that we're going to where the Sunshine Ordinance is no longer like plausible.
All right, look,
Can I make a motion?
I don't agree with this, and I don't think that we should vote on it. I think it's too hasty. I think we should. There should be other people that brought in that were part of history in creating this, and that are experts in this also.
I'd like to make a motion.
I read this completely different.
She wants to make a motion.
I'd like to call a question and make the motion. I'd like
to second that.
What is the motion?
You second a motion that hasn't been made.
A motion has not been made.
Call the question.
I want to call a question. She's seconding that.
There's no question for what, though? There's no motion on the floor.
What is this that we're talking about?
We're having a discussion about the...
I was asking Victor. I would like to make the motion that we vote on what we've been discussing on, which my colleague over to my right here has made a very persuasive argument about, what was it about? Spreading out the responsibilities. Do you have a better way of framing this? Do you?
I can make the motion.
Can you make this motion?
I'd like to make the motion to not interpret Section 67.21 to require the individual that the request is directed to be the respondent to that request.
Oh, I'll second that.
Point of order.
They're not the person that must
It's
respond.
a point of order. It takes precedence. Go on. Point of order.
Is that adequately notified in the agenda, or should that be agendized for next meeting?
The agenda notes this as discussion and action.
Yeah, action, so we can act.
Well, but where did...
So,
can I make a suggestion for
Section 67.21 regarding the legality of a named respondent in a public records request who is in the custody of records transferring the responsibility of fulfilling the request to another member of the staff without notifying the requester?
Me to respond?
I'm answering your question. No response necessary.
So if you phrased it as 6721, like I'm not going to. I'm sort of restating in a way that is making sense to me. Tell me if this is what you mean. So the motion is that under 6721, a named respond. Well, let's see. Somebody who is in custody of records may transfer the responsibility of fulfilling the request to another member of staff without notifying the requester.
Correct.
Okay.
Is there a second?
Oh, I seconded, didn't I?
Okay. Is there any public comment? No public comment.
This person's been here the whole time.
He's having a great time.
Even my friend.
So I'm going to move that we continue this item.
But there's a
It takes precedent to continue the item.
I have a question.
I move to continue the item. Is there a second?
Sure, I'll second that.
Okay. Is there any public comment on continuing the item? Seeing none. Any further discussion on continuing the item?
I mean, the only thing I'll add is that I feel like the last time we discussed this, you had said that we were going to bring in somebody who is an outside expert who had been an author to come talk, and we don't have one here. So I'm just wondering that if we continue it, how are we going to get an expert to that meeting who's not at this meeting?
The issue around trying to get somebody at the last meeting was dealing with the holidays.
No, we were supposed to have one at this meeting, and then we don't have one at this meeting. And so...
Granted.
You know,
I'm dealing with people's schedules, too.
We have the motion that the chair made on
Okay.
the floor that's been seconded. Are you going to call
Member
the roll?
Josh Wolf? Hold on. You know what? I'm running this meeting, okay?
I was just going to respond to Member Moss that the inspiration for my second is in continued want of that expert.
Kate, may I?
Could the motion be that we don't have a hearing on this until there's actually a confirmed expert here?
What?
Is that something
do that.
possible?
Can the woman ever
I'm okay
speak,
with
or
that.
do we just get
I
pushed aside
apologize.
every time?
You can ask. I will take it in line. Let's not have people
I
talk
get
over
skipped
each
over
other.
each time.
I'm
feeling all this talk about an expert feels that it's not even taking into account people like me that have been on this board for 6 years. So I've given you my opinion. I was chair and vice chair of this organization. I don't see this great messiah coming in that's an expert that's going to tell us anything that we don't already know. And I'm taking it as a slap in the face hearing this word expert over and over and over when I've been on this board for 6 years.
Call a question. Go ahead.
On the motion to continue the matter, Chair Wolf.
Aye.
Wolf, aye. Member Josh Wolf.
Aye.
Wolf, aye. Member Hensy. Highland, excuse. Eldon, excuse. Copra, absent. Member Tesfa.
No.
Tesfa, no. Member Moss.
No.
Moss, no. Member Kanata.
No.
Kanata, no. Member Fisher.
No.
Fisher, no. Member Hensy.
Aye.
Hensy, aye. The motion fails.
Okay, so now we're back to the original motion. Okay, any other discussion on it?
Yeah, I have just
Member Canale.
on the original motion. If this motion passes, what does it mean?
It means that if it's the position of this task force.
That the position of this task force is that a records request to a department, regardless of who is named, can be answered by a custodian of record.
No,
in that department?
you're mixing two things. There can be a request to a department, and there could be a request to a person. If there's a person who's been named as a requester, that the motion on the floor is that they can transfer that request to some other person without notifying the requester. That's what's on the floor. Member testify.
Just in response to that, we'll be voting that that's the position of the task force, but you can still vote however you want when that issue comes before us. But if someone on the task force asks, oh, what's our position on this? We have voted on this. So you can still vote however you want in the future.
Yeah, but this basically will be more or less how we will adjudicate cases in the future. That if somebody makes a case and says, I asked so-and-so A for this information, I got information from so-and-so B, when so-and-so A actually had the information, our position is going to be, did you get any information? And that's going to be yes.
No, I think our position is going to be, did you get all the information?
They wouldn't know. If they found out late, the point is if they found out later that it wasn't all the information and it had a significant effect on them, property, money, they had a loss, they were harmed by it, when the information could have been gotten. That's the point I'm making. Okay, and coming here is after the fact. So that's the point. So I'm not going to support this, but essentially the task force is basically telling the city that they could hand these requests off to somebody who has no knowledge of it, provide some information that the public is going to feel like they got all of it when they may not have, could possibly be harmed by it, and they're going to show up here and we're going to say, well, that's our position. I think that's a travesty. I think that's harming the public. Go ahead, member testify.
I'd like to call the question.
Please call the roll.
On
did we take public comment on this?
I believe we have.
Any public comment? Just the last time, no public comment. Okay, call the roll.
On that motion, member Tesfa.
Aye.
Tesfa, aye. Member Fisher.
Aye.
Fisher, aye. Eldon, excuse. Member Josh Wolf.
No.
Wolf, no. Copra, absent. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Hinsey.
No.
Hinsey, no. Highland, excuse. Chair Wolf.
No.
Wolf, no. The motion fails.
Okay. So, I mean, I guess we're going to have to come to some agreement at some point. Okay. I am not saying I'm going to bring some higher power to come in here and make a convincing statement. It's for your edification as information. And if it speaks to you, fine. If it doesn't speak to you, fine. Bring in, if you want to suggest somebody to bring in, fine. I think I think that's great. Let's do that. But I think this is an issue that's split among this task force. Go ahead, member testify, and then member Josh Wolf.
And I would like to offer myself as someone who has been using the next request system for quite a while, longer than anyone at the city, to speak at that meeting on how it actually works and how these processes actually move along.
I'm just a little confused that the motion to continue it didn't pass, and yet you're acting like it's continued, so I don't understand how that actually
No
works.
action has occurred at this point,
Right.
so it is in limbo.
It can appear on the agenda.
Yeah, it can. I can just leave it on the agenda, and we can have further discussion. That's what I'm suggesting.
So it's essentially like a pocket continuance, even though the formal continuance didn't pass.
Well, I mean, I create the agenda. So if I want to have it on the agenda.
I'm not trying to be aggressive with that question.
Okay.
It was a legitimate.
No, I'm being honest with you. I mean, it's if I feel that this is important of an issue for the task force to consider and to have discussion or debate about and deliberate and make a decision, because I think it has a drastic effect, then I'll put it on the agenda, as I did. Okay, so the fact that it didn't the purpose of my continuing it was to block the vote. Okay, that was the purpose, was to block that motion on the floor from moving forward, so that there could be continued discussion. That's all dispensed with now. Okay, so I don't think that we are in agreement still. I think the jury's still out on this. I'd like for us to get some consensus, and however, consensus sometimes takes a long time, and it demands hearing from people and ruminating on it. So I'd like for us to continue to do that, and if any of these kinds of cases come up, then we'll deal with them on a case-by-case basis and see if we can get through them. I just don't want to have a contemplative session in the middle of a case that then pushes the case, an hour, 2 hours down the line, and we're still not getting to an end point. And we would have to continue it anyway, because there wouldn't be agreement on that particular point. So that's where I stand on it right now. Okay. Does that sound comfortable to folks at this point?
And may I suggest I actually write out the question for the next time this is agendized?
Yeah.
Of what the vote is going to entail.
Yes. Yes, Member Moss.
So in doing so, could we make sure that we include an analysis of 6253 of the California Public Records Act? I know during debate I didn't bring this up, but I mean, part of my concern is that there may be a conflict in some interpretations of the Sunshine Ordinance that is in conflict with the Public Records Act in not a way that is limiting transparency or expanding transparency, but is actually causing a problem where on one hand it might be saying that if the agency doesn't respond, like for example, the Public Records Act says that, if there is if the time limit is going to go beyond whatever, the actual head of the agency or the head of the agency's designee has to respond. Whereas the Sunshine Ordinance just says a custodian of records, which could be anybody. And in my mind, having the head of the department having to make that determination is better for transparency than having a rank and file employee make that thing. So I would like it, if we're going to be doing a deeper analysis of it, that the next version of this not just do 6721, but also in context of 6253.
6253. Okay.
6253. Yeah.
So the only thing I would suggest is there's a and I don't know what the statute number is, but in the CPRA it speaks that local agencies can create enhancements for greater transparency and expediency.
Right. And all I'm saying is that I don't think that this necessarily is a matter of greater expediency, that if you actually make it if a local ordinance makes government less accountable, that is not in compliance with that part of CPRA.
Okay.
Like an agency, we can't pass an ordinance that says agencies don't have to respond to public records anymore, only individuals do. That's not legal. So I mean, it would be good to have that in consideration as well.
Yeah. Totally got you on that. Good. Very good. Any other points? Okay. All right. Moving on. Next item.
Next on the agenda is item 10, report from Sunshine Ordinance Task Force committees.
Any reports? We can go down the line. Complaints Committee?
I was absent from the January meeting, but I'm looking forward to meeting again on February 27th.
Okay, and I want to thank Member Fisher wholeheartedly for stepping in for me because I was stuck in an emergency and too far away to get here in time. So I really appreciate that. Thank you.
And I
very
was
much.
in stairwell number 1 of 505. I'm sure you know it. And on my way to a wine tasting when the call came.
Oh.
I went, and I looked at, and Victor's face popped up, and I went, well, my first thought was, am I missing a meeting? And I thought, he might need me to come to a meeting. And
The perks of working across the street.
Petite Syrah, public duty. Petite Syrah, public duty. Merlot, so.
Is this just because you're higher in the alphabet than?
She worked right here. So I worked right across the street.
So
No, I was going to the wine, and there was no wine here. Like, hello.
I will offer an open invitation to take you out for a glass of wine. Whatever you like.
Yeah, I'll take that
I
one,
appreciate
that
it.
one.
Thank you.
But nobody else is invited because that might
Brown
present
Act.
some Brown Act.
We can have, what's the rule? We can have 5 of us. That's it.
Okay. All right. Complaints and amendments.
We
Anything to
had
report?
one of the cases we heard, which is going to come forward, I believe, had an issue about requests for future data. So this will be an interesting discussion because we started a little bit of it here. So.
Okay. Very good. EOT?
I don't think we've met since our last task force meeting.
It's been quite a while, yes.
Did we commandeer that for the
Yes, we did.
special meeting? Yeah. So, okay. All right. Rules Committee?
We haven't met since.
Nope.
I don't know when. But
No rules to rule.
Okay. We do have a few items, though, I believe Victor was saying.
Okay.
But
and there's nothing from the IT committee
we haven't
yet.
met in a while either.
No, we haven't met in a while either. I'd like to get the new digital services czar in to tell us what they're doing around. They're doing a lot of sunshine work around website development for all departments. So it'd be good to get them in here to give us a run through. Okay, next item.
Item number 11, Sunshine Ordinance Task Force Chair's Report.
I don't think I have anything to report. I don't have anything in my notes. Nope. I don't have anything. Is there anything for me that people want to bring up? Nope. Okay. Call next item.
Item number 12, Administrator's Report, Complaints and Communications. I have listed the next few meetings for the committees. EOTC is meeting on February 20th, 2018. If you are on that committee and cannot attend, please let me know. The Complaint Committee is meeting on February 27th. And then the March meeting for the task force. We had very few new complaints in the month of January. There was only 2 new ones. Our pending complaint list is actually going down this month from 57 down to 48. And we have the continued listing of pending issues before the task force. And regarding my emails that I sent out this week, the Ethics Commission deadline is April the 2nd, I believe, for submissions of the Statement of Economic Interest and the 2 declarations. I believe 9 members of this task force terms will be expiring on April the 27th. And,
except for 2.
Except for 2, yes. Applications are available on the SFBOS website for your review. And there have been indications that several members of this task force will not be reapplying. And I was going to suggest maybe we should recruit new members and so forth. And I believe there's information regarding some of the other seats, like the California New Media seat, that we are still working on.
Right.
But any help in getting us a good pool would be appreciated.
Yeah. So poke your networks. Member Fisher.
Question. So the Form 710, 700? 700? Then what's the 710? PU code, PU code 710, VoIP. That's what I'm confused
Form
with.
700 is the same one you filled out when you started there.
Yeah, I know. I don't know why I'm stuck on 710.
There's
So
an FPPC 710, I
I think that's what I'm confusing with. It's due April 2nd, and our terms go until April 27th, so we have to fill it out?
Yes,
Or does
you
it,
would.
So it doesn't, it's not like for next
You would
year?
be
it's for,
fined if you did not. It's still due.
Yeah, I know.
Yeah, it comes at the end of your, kind of the end.
Yeah.
But also the 2 other documents are, one was the ethics training, the other one is the sunshine training. So you got to make sure you get those in.
Well, those are, you just have to promise
They're
to
all
do them
No.
by the end of the year.
We were supposed to already do one of them.
Yeah.
No, the ethics
We did it.
one, you have to go through the whole thing.
Do that, but the sunshine you do at the end of the year.
Yeah,
or
right, that
whenever.
one.
I think I did it at
That
Christmas.
one's more of a promise, right? Exactly. So just so you're aware, that ethics training takes a while to slog through.
Yeah, and they don't let you go too fast.
They don't let you go too
I know,
fast.
it tells you to slow down.
And it actually is pretty thorough, to tell you the truth.
So
And I'm
wait,
sure you've had to go
I just
do it at the state level. Yeah, same here. They run you
This
through.
one is like a test, like a
No,
real
we
test.
actually had to take a test. Yeah.
Okay. All right.
For law.
Next on the agenda is item 13, announcements, comments, questions, and future agenda items.
Anything for the good of the cause? Nope. Seeing none. Okay. Last item.
Item 14, adjournment.
Is there a motion to adjourn? Is there a second? Moved by Member Kanata, second by Member Tesfaye. We are adjourned at 8:45.